Great, looks like we are live. Welcome everybody to the second meeting of the Provisional Licensure Working Group of the State Bar of California. This is a meeting that is open to the public. It is being recorded. I want to remind folks that if you are not speaking, to please mute yourself and to turn off your camera if you need privacy. Ezra, if you could please call the roll for the working group.
And so I'm not going to be looking at the screen, so if you could just announce yes, you're here or present, that'd be very helpful. Thank you. Okay. Hylan Chin.
Here.
Ruben Duran.
Present.
Robert Barrett.
Here.
Rupa Bandari.
Here.
Ann Boyer-Vine.
Here.
Julie Christ.
Here.
Terry Garland.
Here.
Dolores Heisinger.
Here.
Jennifer Henning.
Here.
Judge Herman. Judge Herman.
He couldn't make it today.
Oh, okay, thank you. Paul Kramer.
Here.
Carol Langford.
Here.
Laraz Moody Villarose. Laraz Moody Villarose. Cindy Panuco. Cindy Panuco.
Here.
Thank you. Vern Pearson. Vern Pearson. Judge Rodriguez.
Here.
Angela Sierra.
Here.
Philip Talbert. Philip Talbert. Here, thank you.
He's here.
Okay, yes, thank you. Tiffany Townend Blacknell.
Here.
Thank you. Did I get everyone?
I think so. Did you call on, and I noticed that Neil Gupta and Greg Fortescue are here as well.
Yep.
Awesome.
Oh, okay, yes.
Thank you guys. Donna, are we going to start with the comments from the Legal Services Funders Network? Are they ready to go?
I thought we'd start with public comment today, and then we would turn it over to the Legal Services Funders Network
Got it.
postgraduate fellows.
Okay. Looks like we have 18 attendees. Do you want to run public comment?
Absolutely, happy to. If you want to make public comment will be limited to 2 minutes. Please raise your hand by clicking the raise hand button at the bottom of your screen. If you are calling in by phone, you can dial *9, and that will also enable you to raise your hand. With that, let me just get my timer ready here to make sure that we are equitable with regard to everybody's time. Okay, with that, let's see, we have a hand raised for public comment. Ezra, if you would provide Mr. Sarkar with the microphone.
You should be unmuted.
Good morning. My name is Julian Sarkar. Can everyone hear me okay?
Yes.
We can, thank you.
Thank you. My name is Julian Sarkar. I represent attorney applicants against the fraudulent and discriminatory business practices of the State Bar of California, as well as the National Conference of Bar Examiners. I understand that today's meeting is to talk about the provisional licensing program in which persons will be given some kind of a second-class licensure before they're required to prove their minimum competence through the California Bar Examination. I just wanted to discuss some of the items that I've had to pick up in terms of actual skills that I think are necessary that I hope will be implemented in the program for this the class of 2020 that will be eligible for this program. Back in 2016, the State Bar of California and the National Conference of Bar Examiners, they bullied my friend and his my law school classmate into taking his own life, and showed complete indifference as to that, before proceeding the following year to continue to revamping the examination to ensure that it made $20 million in revenue that following year. What I've had to learn, throughout the course of my practice is, that how to try to force the constitutional obligations of the State Bar of California. In the course of in my practice, what I've had to learn, for example, is going through some of the historical records of both the State Bar and the National Conference of Bar Examiners. What I've learned is that the reason why the public has not been able to understand this sort of inconsistency with respect to the purported mission of protecting the public of the State Bar and the actual conduct of the State Bar is because historically, where that term comes from, it's not clear exactly when that euphemism was adopted. The original.
Mr. Sarkar, your 2 minutes is up. I need you to wrap up now.
Okay. Well, so what I would say is that I hope that this program will include actual fact-finding skills, such as discovering the white supremacist origins of the attorney admissions program of the State Bar of California, in addition to the skills that are taught in law school and tested on the bar exam. Thank you.
Thank you, Mr. Sarkar. Okay, I don't see any further request for public comment.
Great, thanks, Donna. So we have, is it 1 or 2 people, Donna, from the Legal Services Funders Network?
We have 4 people who will be presenting.
Okay, we have 4 people presenting from the Legal Services Funders Network. We heard from them last time during public comment. And they are here to talk about their thoughts on, hopefully on provisional licensure. They are also advocating for a progressive license, but we'd ask them to limit their thoughts to the provisional licensure that's before us.
So Ezra, if you can, for the purposes of this presentation from the Legal Services Funders Network, if you can promote the following individuals from attendee to panelists for this moment: Claire Solat, Charlotte Arel, apologies for mispronunciation, Tom Rivera, and Jessica Juarez. I see Charlotte, I see Tom, Jessica. Just get Claire up there as well, as she'll be starting off. We've got Claire. Perfect. I'm going to share my screen to put the slides up. Let's see, got that screen. And can everybody see my screen? Is it?
Yes.
And it's the LSFN Postgraduate Legal Fellows?
Yep, you got it.
Okay, perfect. With that, Claire Solat, I'd like you to, if you could introduce yourself and begin the presentation.
Thank you so much. Thank you all for allowing us time today to present to you some more thoughts with regards to the provisional license. As was mentioned earlier, I had the opportunity to speak during public comment on the 7th, and much of the information that's on the first slide is a synthesis of what I spoke about on the 7th. I'm not going to take a lot of time right now because what's important for you to hear is from our actual legal fellows, but I will join you at the conclusion of their comments with a wrap up. The 3 fellows we have today are just a small sample of the amazing 28 legal fellows that we've placed in legal service organizations in the Bay Area, and they are exactly the type of new attorneys that we need to bring into our sector. So with that said, I'm going to turn comments over to our first legal service fellow, and that is going to be Charlotte Arel.
Yes, hello, good morning. My name is Çağıl Arel. I go by Charlotte. I am originally from Istanbul, Turkey. My first language is Turkish. English is my second language. I received my JD from Golden Gate University, and I'm currently clerking for Social Justice Collaborative doing defensive asylum. I'm going to walk you through the timeline of an immigrant law student who just graduated. If you could change the slides, please, to the next slide, I'd really appreciate that. Thank you. This timeline applies to myself and all applicants under the student visa. So we started mid-May when I graduated law school. I must leave the country within 60 days of graduation. Therefore, I cannot take the bar exam in July unless I apply for the OPT program. OPT is a program that allows me to work up to 1 year in the US if my job is directly related to my field of study, which is the law. I have no choice but to apply for OPT if I want to take the bar exam. If I'm approved, I have 12 months to stay in the US until July 2021. However, 3 months before the end of OPT, in April, I also must apply for a work visa to work as an attorney. Again, once I'm accepted to OPT, I have 9 months to apply for a work visa and 12 months to remain in the US. In the OPT program, I have to be employed continuously, and I cannot take time off to study for the bar. If the bar exam takes place in October, as currently scheduled, I'll receive my results in January. At this point, 6 months have elapsed, and I have 3 months left to apply for a work visa and 6 months left to remain in the US. On top of that, I would receive my results a mere weeks from the February 2021 bar exam date. As you know, this is not enough time to re-prepare for a bar exam. The next exam after that is in July 2021, at which point my 12 months will have run out. Given these circumstances, October is my only chance to take and pass the bar exam. My only other option at this point to utilize a temporary provisional license until 2022, which requires me to have a work visa. Work visas require a sponsor, and most employers are highly resistant to sponsoring unbarred graduates. So again, functionally, I really have one opportunity to take and pass the bar in October. Let's also keep in mind that I must be continuously employed and working in the time leading up to that one opportunity, so I cannot even take time off to study. However, if I'm allowed a progressive provisional license and be allowed 1,000 hours of supervised work to become an attorney, I can stay in the country and complete my bar admission requirements before my time runs out. So taking the bar as much as we need to under the temporary license approach does not work well for people like me. Thank you very much.
Thank you, Charlotte. And as noted on this first slide, 17% of Golden Gate Law University's students are international students. We tried to find a figure for the entire state, but could not at this point. But as you can see, it's a substantial population of students that will not be able to take the bar exam multiple times. So in thinking about a provisional license and the various opportunities that are offered, I think that it's important for this group to actually look at the reality of whether the multiple exam scenario is feasible. The next speaker we're going to have is Tom Rivera.
Good morning, everyone, and thank you for your time. My name is Tom Rivera. I graduated from Berkeley Law just this year. I'm also the first in my family to go to college, the first to get a graduate degree, and I'll be the only lawyer. And since June, I've worked in the tenants' rights practice at Centro Legal in Oakland. It's been a busy time. In addition to studying for a novel online bar exam, helping my family navigate COVID scares and federal assistance, I've also been counseling and defending Bay Area tenants against illegal rent increases, harassment, and actual and constructive evictions. And despite the pandemic, evictions will soon be coming in mass. Millions of California tenants, as a result of the pandemic, have lost their jobs, or their income is tied up in things like food, medical expenses, or childcare. And ironically, the first people to be evicted during the pandemic are the same essential workers that have carried us through the entire pandemic. But on September 1st, the courts will begin hearing eviction suits again. Landlords and their attorneys will once again be legally evicting tenants like they've done before. And state and local protections only work as affirmative defenses. Tenants need lawyers to assert those defenses in court, or they'll lose their homes during shelter in place. But unfortunately, I won't be there to fight for my community when it needs me most, because I'll be studying for an online test that may or may not happen. But a provisional license could actually allow me to work, and I'm ready to go to work if you'll let me. Whatever this group ultimately comes up with, the provisional license has to at least be more expansive and flexible than the current PTLS program that we're all part of. It also has to give supervisors the flexibility to actually fit the provisional license into their practice and the needs. It should be easy to obtain for us and not overly burdensome administratively. And it has to be available before the October exam and offer a realistic alternative to the October exam. However, if provisional license comes down, it won't be worth it if it in any way penalizes us for deciding not to take the exam in October, or if it charges an additional fee on top of the thousands we've already paid to the State Bar, or if it imposes inflexible supervision requirements that will deter employers away. Ideally, a progressive license would be in place because that would allow me to actually work toward earning a license while I'm simultaneously already applying my skills and focus to keeping people housed during a pandemic. It will also ensure that I have real world experience before becoming licensed, because right now the system allows someone to become fully licensed without any meaningful experience. Now, this committee has the authority to recommend whatever it decides, and this is the perfect opportunity for a progressive license pilot program that can actually meet the challenges of COVID-19 and will lead us into the future of deciding how to license attorneys in California. So I urge you to seize this opportunity. Thank you.
Thanks so much, Tom. Our last speaker is going to be Jessica Juarez.
Good morning. My name is Jessica Juarez, and I graduated from Golden Gate University School of Law. I'm a first-generation Latina graduate and professional. Spanish was my first language, and I'm a single parent of a 10-year-old daughter named Evelyn. I'm fortunate to be able to work here with Homeless Action Center. Homeless Action Center provides no-cost legal representation to the most vulnerable people in our community. It is a humbling experience to work with this community, and this experience solidifies why I want to be a public interest attorney. As a recent graduate and single parent, there are several challenges that I'm facing, and it is incredibly difficult for me to decide whether to take this exam in October or take a gamble in my future in income by waiting for a February exam that may or may not happen. Being able to secure a space to take an exam is one of those challenges. I live in a studio with my daughter, and I don't have one room to myself. In fact, I plan to take the exam in my kitchen, right here where you see me right now. But there's also other challenges. With the COVID-19 pandemic, most childcare centers are still closed, and the few that are only open to essential workers. Schools are still closed. My daughter started her 5th grade yesterday, and it's on remote learning. And rumor has it that they'll be there for the whole fall semester till December. I'm also facing extreme financial hardship, and it is only because of fellowships like this and benefits such as SNAP that are keeping us barely afloat. There's also the possibility of being disqualified based on the AI proctoring, such as random noises from the neighbor or power shortage we have no control over. A traditional bar exam doesn't work for all of us. Even if we were to take the traditional bar exam after fulfilling all of the progressive provisional license requirements, it would be counterintuitive. A traditional exam is designed to take within 2 months of graduation where the information is still fresh in our minds. We need another option. I am an ideal candidate for the progressive provisional license. My daughter has gone through this entire journey with me and has made sacrifices. She recently confessed to me that she's afraid that she will accidentally make noise and ruin this for me. I would hate for her to think that she is the reason for me getting disqualified. A progressive provisional license is a more practical option for people like me, and it is something realistic that we can fulfill. I am hungry to work. We are hungry to work. I am personally willing to do any amount of hours, any amount of MCLE credits, along with any other requirements that the board sees fit. This program would not only ensure that we can serve our community in need right now, but we would also have practical experience, and most importantly, have an experienced supervisor that's going to mentor us throughout this whole experience, so that when we finally earn our license, we have proven that we are ethical and competent attorneys ready to serve. If you just give us a chance, we will show you that we can do this and we will succeed. Thank you very much.
Thank you so much, Jessica. In closing, after completing 3 years of law school and taking on tremendous debt, new law graduates like Charlotte, Tom, and Jessica want to join the legal profession and be permitted to help the community. They've given up time from their work in bar prep today to voice their realities and those shared by thousands of bar applicants who've been similarly impacted by current events. There are hundreds of July 2020 test takers like Charlotte, Tom, and Jessica who already have certified law student status and are currently working to increase access to justice. Morphing their PTLS into a provisional license would be a relatively simple administrative task, as they have applications already in the state bar system and active supervisors. All of the options for administering the California bar exam now and until a vaccine for COVID has been produced, tested, and is widely available, have inherent risks. It is anticipated this will likely be the case for the next 6 to 12 months. While some July 2020 test takers will opt to take the upcoming exam in October or February, offering a provisional license that new graduates will actually apply for is an important alternative. It is essential that new attorneys be licensed now. COVID has increased the need for attorneys to assist low-income and middle-income folks as they confront the loss of their homes, jobs, benefits, and stricter immigration rules and enforcement. Less than 20% of current attorneys focus their work on poverty law. After years of increasing numbers, the legal profession is now experiencing negative growth in California. The rate of California attorneys who have become inactive has increased steadily since 1990. Annually, 40,000 attorneys turn 60. And as we know, these attorneys are at higher risk for COVID, and many will limit their practice to remote work even while the courts are open. Yet only 24,000 new attorneys graduated from law school this year, with over 1/3 of these folks based in California. The California Supreme Court is looking to you for recommendations. They've only set the floor for the program. You can recommend where the ceiling is, just in the same way that you are recommending against limiting practice areas, despite the court's instructions in their memo. The concept of an emergency license or a pathway to becoming licensed via supervised practice is not new. It's being explored in other states and in other countries. Similarly, California has used emergency credential programs for education and medicine for many years. It's imperative to act now. The July 2020 test takers have had the exam date moved multiple times and are in limbo as to the terms of a provisional license. The public is in need of more attorneys to help combat the legal fallout of COVID-19. Thank you for your time and consideration. We're happy to answer questions.
Great, thank you so much for that presentation. Are there any questions from members of the working group? All right, not seeing any. Thank you very much for taking the time to share that information with us. And with that, we will dive into the work that is remaining for us.
I would just note that this morning, Ezra sent around some materials that Claire had provided from the Legal Services Funders Network, some background materials supporting the information that was shared today.
All right, thanks very much. Okay, so I just want to give you a brief overview of what our plan is for today. Ezra circulated the draft rule of court in an email that was sent yesterday around 2:36 p.m. That includes some very hard work that Terry Garland, Tiffany Townend Blacknell, and Carol Langford did in coming up with a proposal for this group to consider with respect to limitations on practice for the provisionally licensed lawyer. So we're going to start there and use that as a launching pad to go through the remainder of the decisions that we had yet to make. Once we're done with that, we will go back and cover some of the questions that may be related to the stuff that we already decided and that are meant to be memorialized in this draft rule. All right, okay, so just to orient folks, we are going to be starting with, if you're looking at the draft provisional licensure rule, we are going to be looking at section G, which appears on page 3 of the PDF. So we're looking at section G, which is titled Limitations on Practice. That's at page 3 of the PDF. And then for folks who want to refer back to the chart that was in the memo that we were working off of last time, we are looking at the charts that are on pages 10, 11, and 12. And these go to limitations on practice. So why don't I first kick off the first topic, which I think is, and this is the one that we spent a lot of time on last time, which is the issue of what notice should provisionally licensed lawyers give to their clients, and whether there needs to be consent from the clients. And it looks like the recommendation from Terry, Tiffany, and Carol is that notice should be given. So if you look at G1, there's the express disclosure requirement, but there is not a consent requirement. And I didn't know if one of you wanted to speak to that.
Haley,
Hey, Carol, go ahead.
I can just tell everybody kind of what we were thinking. We talked a lot about it. And our biggest concern was big groups and big law firms, essentially, the public defenders. Tiffany had a lot to say on that too. And, you know, we talked about everything from informed written consent to disclosure. We know the Supreme Court wants protection of the public. We were concerned if we made it too strict that nobody would hire the provisionally licensed lawyers, because you just couldn't get it every time. I mean, in a public defender's office, they can have, you know, tons of files, and it's hard sometimes when you're out there doing your deals or whatever you're doing in court to always get people to sign something. So we figured the best idea was to have it be just a disclosure, which is an oral disclosure. The government agencies, and to protect themselves, are going to do like just a form for people to sign. I think is how they're going to do it in the beginning anyway. So the provisionally licensed lawyer just says, I'm a provisionally licensed lawyer. And we figured that would be the best approach, because it's workable in all situations. Because we're talking about not just small firms, we're talking about the public defender, we're talking about state agencies, and it's going to be hard. They won't want to hire them if the requirement is too strict on that. So that was our thinking.
This is Paul. The word expressly, I'm not sure captures that. If you really mean that oral disclosure is good enough, we probably should be clearer about that. My only concern is if it's important to us that we can determine whether or not they've made this disclosure, anything less than a writing makes the whole thing ambiguous. I don't know how important it has to be to us, but I'll just make that point. And then in paragraph 2, it seems, again, it's not clear to me. On the one hand, paragraph 2 seems to be wholly, or at least mostly, duplicative of a statement that was made in an earlier section about disclosures, or about the use of the descriptive label of their status. And I wonder if it needs to be in there. But as it is, I wrote a question to myself: does that mean they have to make this referral in every conversation they have with a client, the initial conversation? It just seems vague to me.
Well, that is why we put at the outset of the representation, so that they didn't have to every time, because we did talk about that. By expressly, I get what you're saying. Does it make it clearer if you say orally? See, disclosure has a meaning, I guess, ethically, in that it's not informed written consent. Disclosure can be in writing. Disclosure can be oral. It can be either one. It doesn't have, unless the rule says it's writing, it doesn't have to be in writing. The word expressly, that's you're right, it does create a little ambiguity because normally you just use the word disclose. So I'm wondering how Greg or others, how do you feel about that, thinking of the rules, the ethics rules that we wrote, not using the word expressly?
And then Diane, do you have a hand raised?
Yeah, just that I think added to the ambiguity is in one you say expressly, and then in two you say expressly and you use orally. So it's confusing to me whether one is something other than orally. So I'm just kind of echoing Paul's comment.
And I also note in Rule F2, they're already required to only use the term provisionally licensed lawyer. I wonder if that doesn't cover everything we're trying to say in G2, or at least most of it.
Yeah, that's a good point. I think it should just be in one place.
One thing to point out is I do believe that we could use F2 to do a lot of this work, but it talks about how you describe yourself. I think that if we just went with F2 and G1 and take expressly out of G1, we would probably accomplish all of the goals that we intended to reach by this. So that you're making sure with G1 that at the outset of the representation, the client gets disclosure of the status of the lawyer, provisionally licensed lawyer. And then with F2, you're making sure that in other descriptions, such as anywhere else, that there's nothing misleading in the way that the provisionally licensed lawyer describes their status.
So let me ask this: F2 is lacks the detail of G2, and so is the recommendation to go with the sort of less specific F2, or move the detail from G2 to F2?
Well, I was thinking that although F2 lacks detail, it's very broad. So it says, don't describe yourself in any way or imply in any way in writing or orally. So it doesn't have the detail, but it's very broad. I see Diane has a question.
So I'm just looking at this for the first time. I'm sorry. So now I'm a little confused because G talks about how you must, provisionally licensed lawyer must do these things, right? I mean, F does, and it's entitled the responsibilities of them, and there is duplication on G2, but there's also a little duplication with G3 because it is also somewhat contained within some of the requirements of F. And I'm now not seeing anything but number 4 as an actual limitation on what a provisionally licensed lawyer can do. And that's the heading. And I know headings, at least in statutes, don't matter, and I don't think they do in regulations, but they still give a roadmap to people, right? So I'm looking at this and I'm looking for a limitation in G, and I'm only seeing a real limitation in number 4. So just thoughts on drafting.
Good point.
Yeah, I think that makes a lot of sense, Diane. Well, how do folks think about the concept of not requiring consent? Just
Hey, Helen, can I just say one thing? Because I think Diane and Terry's points are good, and I think they might be easily resolved in that I think 2 is broad, and its responsibilities of provisionally licensed lawyer. It goes more to advertising, because those words are in our advertising ethics rules about holding yourself out. But it also goes to pleadings. It goes to everything. So if we look at G is different. G is about disclosure. It's not about holding yourself out in advertising. It's a little bit of a tweak. So if we kept 2 in F, I think 2 and 3 of G could go out. We kept 4 because that is a limitation. And 1 in G. 1 does not really go under G. I think it goes under F. Then we get rid of that duplication, as Diane and Terry are saying, because they're right on that. And it's clearer.
Yeah, so I agree. I would just say that G2 does have the specification that you have to include that on your pleadings or on papers filed in court. And so I wonder if you want to specify that up in F2.
You could. It's a little duplicative though of 2, which is very broad, but you could. It wouldn't hurt to make it clear. It's also pleadings. That's not going to kill, it's not bad to do that.
Yeah,
I just think that without it, you could think that, I mean, because on pleadings, you don't necessarily describe yourself as like, I'm an attorney. You don't necessarily say that in your pleadings all the time.
Right, you don't. And it does make it clear that they would have to if you want to do it, but it's still an issue of holding yourself out like F2 is. So maybe, it's like in our rules, we have comments that discuss the rules and how they should apply. So, and that's okay to do. So we could do that in F for sure and put that part about the pleadings.
Yeah, I think we could list it as an example, like including, this requirement. Because I do think there's something special about court documents, and usually there's a requirement on a lot of them to put a state bar number. There won't be one here for these folks. Maybe there'll be a PLL number. I'll leave that to others, but there is some designation. So we don't want to do anything that would be seen as possibly misleading to the public about the status of these folks.
We've got a few hands raised, starting with Neil.
Sorry, so just going back to the informed consent issue and the notice issue. Judge Herman couldn't make this meeting, but he wanted me to communicate that he's strongly in favor of having informed written consent by the clients. And I'll also defer to my colleague, Greg, who knows the professional rules of conduct better than anybody on this call. But I don't know whether a compromise might be to have a requirement in G1 where you have at least written notice being given to the client. So that way, at least that reduces the probability of some sort of argument down the line, or litigation down the line, or malpractice claim down the line that they didn't receive proper notice. I'm just throwing that idea out there. So.
Greg?
So Neil, I would say that, if I were advising the firms that are part of the LAS, I would recommend that they make the disclosure in writing. But I can't speak to how onerous that would be on some folks like government lawyers and public service lawyers. But it's not I think the hard thing would be, and the thing that we would worry would place too much of a burden and result in these folks not being able to be hired, would be getting the signature back from the clients. I mean, if some employers might just say that's just too much to deal with. I'm not going to hire somebody that has this unique burden that might interfere with our ability to retain clients.
Well, we did discuss that. We discussed that a lot. And that's why we put in it, because we were worried. The Supreme Court has been very clear last time that they want protections for the public. So we went over, okay, how is that going to work? And that's why we put at the outset, because even a big office can, when the clients come in, have them sign a form, provisionally licensed lawyer. And we thought that was the way to do it. We put it at the outset. They sign it with the fee agreement, or with the agreement at the public defender's office, for example. I will let the public defender represent me, provisionally licensed lawyer. You can put a little paragraph in a fee agreement. So it's really, and you have to have a fee agreement if representation is over $1,000 anyway under 606A. Some lawyers don't get it if it's less, but that makes it easy at the outset. And that's why we worded it that way, because we didn't want it to be you know, having to come down the line or whatever, when it would be much harder. They just sign it when they retain the lawyer or the government agency. So that was our thinking.
But what
So
about
Carol,
existing matters?
can we hear from Tiffany? Just because I think it would be good to hear get her perspective from the LA Public Defender's Office. And then I know Greg has his hand raised, and we've got a couple more hand raised from Ruben and Professor Barrett as well.
Yeah, thank you. So I am concerned that, so just to give you an example of how fast-paced, large misdemeanor assignments are in downtown LA, for example, you'll have a team of lawyers who are working in a courtroom. You'll have a few who are in lockup, who are interviewing clients, a few who are in the audience for people who are out of custody. They'll do their consultation, make the decision about the next steps, hand that off to another attorney who's running calendar, right? So it's kind of fluid the entire time. And then if the person doesn't enter a plea, they go on to the next stage, which is pre-trial, where a new batch of attorneys are handling their cases. Assuming they enter a plea at that point, they are coming back for progress reports to see how they're doing on probation. Another attorney handles that matter. Or they go to trial. Another attorney is doing trial. So there are so many attorneys who are touching that client's file that to have them sign off every time they may or may not interact with the PLL would just be too onerous. I don't see a way that we would be able to implement that given the volume that we handle in misdemeanor courts. And it would be the misdemeanor courts who will have the PLLs, obviously. I think currently when we do the PTL program, we have consent, written consent. But when we discussed it yesterday, we thought that would be up to the individual employer to employ their specific criteria. We do it for IAC purposes, obviously. And we'll probably have more supervision than you all could ever require of us. But I would hate to have the program rejected by our office because it required too many separate notifications. We have a similar thing with commissioners, right? Commissioners versus judges. Our clients have the right to refuse to be heard by a commissioner. We have that advisement at the outset of their entering to the commissioner's court, and that's a written document they sign, they put it in the court file, and that's that. But so I think that disclosing at the beginning that you may actually be represented by a PLL at some point during the representation and have the attorney, like for example, when I go into lockup, I say, my name is Tiffany Blacknell, I'm an attorney with the Public Defender's Office. So if I was a PLL, I would say, my name is Tiffany Blacknell, I'm a PLL, or expressly say the title with the Public Defender's Office. I think that requirement is sufficient, and saying it on the record when you represent a client is sufficient, and maybe the disclosure and make that oral versus written depending on the office's preference would be my preference. Because I could see us saying that it's too onerous at this point for us to have to stop and advise during each stage of the representation.
Great, thank you. Craig?
I think I would just add on to that. Skipping ahead to paragraph I for the responsibilities of a supervising attorney, it also seems to state that they must expressly disclose to each of their clients at the outset of representation that a provisionally licensed attorney or lawyer may be a participant in the representation. And I would be a little bit fearful that we're putting too much of the onus on the PLL in every instance to make this disclosure, when it's really, from my perspective, the responsibility of the supervising attorney, who really, in most cases, will own that client relationship. I would, in terms of, Carol, what you raised, and about expressly disclose, that's not really a term that we have defined under the rules of professional conduct. We've defined informed consent, which can be oral, and informed written consent, and which just means informed consent that must be in writing, and writing is defined under Evidence Code 250, which can be an email. It can be any sort of document that would fall under that definition of Evidence Code 250. And so what I could see what Tiffany's talking about in her fast-paced environment in the PD's office, how it may be just too difficult in every instance to have the PLL asking for consent, and also whether or not they're going to be in a position to really explain and provide informed consent, because informed consent means you're providing the client the relevant circumstances and the material risks involved, and they may not be in the best position to do that. The supervising attorney is in a better position than they are. And I don't think once you make that disclosure and you obtain that consent, I would say that the only thing that you really need to worry about is making sure that the PLL is not misrepresenting that they are not a PLL or that they're a fully licensed attorney. And that can be accomplished through other provisions that are in the rule already.
Okay. Ruben and then Professor Barrett.
Thanks, Helen. I guess I want to chime in with the perspective of my practice as a civil practice, transactional advisory, and my clients typically have longstanding retainer legal services agreements. So it's not as if my firm hires a PLL, we're going to go and amend the legal services agreement. And so I don't think that that's going to be a one-size-fits-all approach, especially for larger or medium-sized firms. And I think that we can just take care of the notification requirements by requiring written disclosure without informed consent. I think I would tend to follow on Neil's arguments that, you know, it takes away any ambiguity if there's ever a dispute about whether the client was aware or should have been aware that they were being serviced by a PLL. So I would sort of split the baby there with just written disclosure.
So let me just clarify that point to marry what Tiffany was saying, Ruben, with what you just said. Are you thinking the written disclosure that a particular person who is assigned is a PLL, or as Tiffany was describing, written disclosure that at some point during your case, a PLL may be assigned to work on your matter?
Yeah, and I think to be able to accommodate the public defender's offices in similar situations, it would have to be more general in the way that you just described, Donna, in the last part of your section. It doesn't necessarily mean that a supervising attorney in another situation that wasn't in the criminal law field where it's not so fast-paced wouldn't want to inform her client or his client that they've got a PLL working on their case. For example, when I'm going to use a paralegal for a certain piece of the representation, I make sure the client knows that it's a paralegal that they're speaking to or interacting with under my supervision. So, in other words, I think we do need, the flexibility for a general disclosure that a PLL may be assigned to work on your case from time to time to accommodate the need that Tiffany's identified.
Okay. Professor Barrett? You're on mute.
I should have said this sooner, but please just call me Rob.
Okay.
I agree with the notion that consent is cumbersome. In terms of disclosure, I think Greg's idea about the evidence code would do the trick. I don't want to exclude all the people that are, we have a kind of a big firm model in mind or a big public agency in mind, but there are a lot of cases that are under $1,000 and there is no writing. And so for those, and in other places in our rules and in the ABA rules, when they say a writing, that can be a voice message left on somebody's answering machine. It can be a text, it can be a WeChat, it can be a million other things. So I would limit it to disclosure, and I agree with Tiffany that it could be at the outset saying generally you may have a provisionally licensed lawyer, and I would suggest that disclosure can be under anything authorized by the evidence code as a memorialized, I don't want to say a writing, memorialized disclosure. Thank you.
Great. Let me call on Jennifer and then Carol.
I think what's being described here is workable also for public agencies where, you don't have fee agreements at the outset of representation in the same way that you would in a private law firm. If it's basically just a general disclosure to the agency, whether that's the governing body or individual departments that a PLL may be working on your matter. If a county counsel's office, for example, decides to undertake this program, it does put the agency on notice that you've got this PLL working under supervision of an attorney, that it doesn't create undue burdens and avoid some of the problems that I think you would have in law firms where there would be other opportunities for disclosure that aren't similar for public agencies. So.
Great. And I will just comment that from a private big law firm perspective, this seems totally workable to me. I mean, we routinely have summer associates working on client matters. Summer associates are not licensed lawyers, and we tell the client, hey, we've got the summer associate who's joined us. They'll be working on your matter. They're going to do some research, and the client says, cool, and we move on. Okay, Carol, and then Angela has her hand raised.
Yeah, I guess I'm not sure it's at this point, Ruben and Rob and Jennifer, I'm kind of agreeing with all of them for the most part, because I think that, first of all, the supervisor is the one that probably should do it. Now that, Greg, just listening to what you were saying, I think you're right. I think it should be a written disclosure, but I think a written disclosure can be an email. So I don't know how we put that in the language, but I think it can be anything. And I think it should be at the outset. That way, even if you don't have a fee agreement, because it's under $1,000, it can be a simple email. Now, I know in practice, like I've been in big firms, I've been in medium firms, I'm in my own, it can be easy to just say, hey, this is Greg, my associate, you do it orally. I think though, if we want to work with the Supreme Court who wants protection, because they said that last time, then the written disclosure at the outset takes care of their concerns. At the same time, it takes care of the concerns of making it easy and workable.
Okay. Angela?
Yes, just a couple of things. I agree with the points about putting this more on the supervisors, because I'm thinking like from a government practice office representing state agencies, it really wouldn't work coming from the PLL, at least at the outset. And a question I had, this idea, and I think this is very workable from a state government office about, disclosing in the beginning that a PLL may or may not be working on that. So just everybody's on notice, coupled with the fact that if a PLL is actually working with client, that they are introducing themselves that way, provides, I think, very helpful notice. One question I have is the concept that we've been talking about including it in, the initial retainer letter. Is that already, are we interpreting that as already being in this rule, or the draft rule is written, or would we be adding that a little bit more expressly? Given that it is a disclosure that this may or may not happen, it's not about a particular individual. Because I think it might be helpful for guidance for it to be more expressly stated in a rule that, a supervisor or an employer can cover their responsibility by handling it that way. But I just wasn't sure, because I haven't read these rules closely enough to see, like, is this already in there, and is this one interpretation of the proposed rule that you could put it in the retainer?
Terry, do you have a response to that? I see your hand raised. You're on mute.
Yeah, took me a minute to get there. Yeah, I think, I don't see anything in the rule that would not allow it to be. I think there's a retainer rule and business and profession codes, I think it's like 6148, around there. It just says it must be in writing, even every time it's reasonably foreseeable that the cost of the client, including attorney's fees, will exceed $1,000. And there are a few things about do's and don'ts on it, and there are some exceptions. So, I don't, I mean, you could put it in the retainer agreement, you could put it in an email. If we say disclose in writing, I think writing is even broader. But one thing, the reason why I had my hand up is that I want to make sure that we don't foreclose just by inadvertence the possibility that folks are going to want to work on existing matters. I think what Ruben was saying about having a lot of long-standing client relationships, a lot of the firms that I work with, they may have a client relationship that goes back a decade, and they have an engagement letter for then. They don't do a new engagement letter for every new matter. And there's one of the exceptions in the BMP code allows for that if you're rendering similar kinds of services to somebody that you've already rendered them to. So I wouldn't want us to say like, oh, these PLLs are only able to work on new matters that come in after they come to the organization or firm, because it has to be in a retainer agreement. I mean, if we just say disclose in writing, you can send the email, you could send a letter, you could do a form.
Right. Now, I agree with that. And I guess it just maybe the rule, rather than saying it's in a retainer agreement, it's just some disclosure that a PLL may be working on it versus a PLL is working on it and this is who she or he is. We're not saying that. We're just disclosing that this may happen, and that writing could be it'd be done in multiple ways.
Yeah, to allow for flexibility.
Yeah, yeah.
And so the reason that you don't see that would go in the supervisor section, right? So we'd remove it from G, we'd put it in the supervision section, and we could say written disclosure. We could either point to a definition in the rules of professional conduct or the evidence code that defines a writing. We could give examples, sort of either way, or we could just say written disclosure. Greg might have some thoughts on what might be sort of the clearest way to do that.
Yeah, one thing I'll just say, it's more of a general note, and Carol probably remembers this from the Rules Revision Commission. Whenever we start focusing in on one rule, the tendency is to try to get the rule to do all the heavy lifting for you. And it really is not necessary. I think if we decide that we need to get informed consent, which is not a requirement in writing, I mean, I'll draw everyone's attention to Rule 1.0.1, our terminology rule, because everything is clearly defined in terms of what do we mean by writing, and what do we mean by informed consent, and what do we mean by informed written consent. But the reason I've raised that is that, and we talked about this last time, Rule 1.4, the communication rule. Even if you disclose, even if we require the supervising attorney either at the outset of a representation or during an ongoing representation in which you plan to bring a PLL in at some point, or may plan to bring a PLL in, if you're what we're requiring is that we just provide written disclosure that may happen, that's fine. Rule 1.4 may kick in again later on if you suddenly decide, not only do I want this PLL to work on this matter, but they're going to actually represent you in the trial, and I'm not going to be there. That would be a significant development, and then you would have to go back again and reasonably communicate that information to your client. So there's a whole set of obligations that the supervising lawyer is always going to be having to refer back to in the rules of professional conduct. And the other thing is, I think what might be helpful is just decide what we want to require from the supervising attorney, and then rather than trying to write the rule right now, because it's really hard to write a rule with 20 people on a call, go back and have some people, and I'm happy to chime in on that process as well, so that we can make sure that we're referring to the rules of professional conduct in an appropriate way and using the same terminology we're already imposing upon the supervising attorney in the rule that we're making for the PLL program.
Great. So why don't we, it sounds like we could have a motion to move this requirement of disclosure to the supervisor's responsibilities, have it be a written disclosure to the client, at the outset, or for an existing matter when something changes, when someone's brought in, and leave it to the rules experts to commit that to a rule. How does that sound?
I make the motion.
Tiffany?
I'll second that motion. This is Judge Rodriguez.
Just briefly, in terms of that requirement, it simply will eliminate the public defender's office at that point. Our supervisors, the supervisor of central training, for example, is the first supervisor that all new lawyers operate under. She has 2 assistants under her who perform all the training that we have multiple times per week. The mock trials, the mock cross, the mock everything. From there, there's like 4 or 5 or more mentors, right? Then there's like more trainers. There's like the central head deputy, her 2 assistants, the trainers, the mentors. She, the supervisor, never goes to court. There's 0 chance she will interact with the client, right? So you will have someone, maybe a trainer or a mentor, who's in court in every division in the central training program, but they're not interacting with clients directly. They're simply there to answer questions, to field controversy, to organize, but they're not interacting with clients. So the idea that one supervisor will go and meet every client, that a misdemeanor lawyer will never happen. And so I can envision a problem where you'll have a trainer who's, typically trainers are pulled from felony trials. They have experience in practicing more than 5 or so years. They're pulled back to be a trainer of misdemeanor newer attorneys, and they move in and out. So they'll be a trainer for a year, then they're moved. And so you'll have this kind of circus of supervisors. If you don't have the head deputy be the designated supervisor, you're going to have a million people who are in and out. And that supervisor, that head deputy, never goes to court. So it just doesn't work for us at all. Not that it has to work for us, right?
But could the rule be satisfied, Tiffany, if the supervisor delegates to one of those trainers to, you know, ask the lawyers to get, you know, hand the client in lockup, here's a piece of paper explaining you may be represented by a PLL?
It would require us to restructure our training program. Because like generally they give us, you know, 4 forms. There's like the reg fee, they did that when I was a newer lawyer. The reg fee, the intake form, and maybe some forms about, you know, the process. And there's like a stack of forms that each lawyer has for each case. And they go in there and they go through the form with the client, you know, pretty hastily oftentimes. But to have a trainer go in and do that process eliminates the need for the lawyer. I mean, if they're going to be going through various parts of the
But could the supervisor delegate through the trainer to the lawyer for the lawyer to give that, just have it be one of the forms?
I mean, I don't know, we haven't gotten to that part of it yet, but does that qualify? It seems that there was a requirement that if you change supervisors, need an additional notification to the bar. You know, will that qualify? Could she delegate to another attorney that duty?
Well, I think we get to decide that.
And you know, I think Greg made an excellent point when he pointed out that there are existing rules. So there are existing rules on supervision, 5.1, 5.3. And in particular, you know, one of the ways that partners and firms handle their supervision requirement is they set up a process. They set up procedures for making sure that there's compliance with the rules of professional conduct. So that concept's already recognized. I think that for your office to set up a procedure for making sure that this form gets where it needs to go, you know, that would seem to satisfy existing obligations.
Yeah, and I mean, this gets back to the way we write the rule. I appreciate that comment, Tiffany, actually. And I think the last time we were talking about how we can make the rules reflect the reality that a lot of you are experiencing in your practices. We're not going to require every time a new supervising attorney or an attorney who is supervising their work, they have to go through this entire rigmarole process, which is just too burdensome and makes the program not worth it. One of the ways you can rewrite that rule is to meet the requirements of supervising it. Right now it says a supervising attorney, you could say a supervising attorney must ensure that, and that will trigger their obligations. And one of the things we haven't talked about so far is any comments that we want to add, interpretive comments to the rules later, which I think we can come back to. But that will trigger that supervising attorney who has been designated with the state bar as the person responsible for this PLL, their obligations under Rule 5.1 to make sure that the attorneys they have supervising their PLLs are doing the things that they're required to do under the rule.
And so I'm thinking about the PTL program. When we use that we don't use that. Okay, so in my mind, these PLLs would be on the same level as our new hires, our bar hires. Because the PTL, they're assigned to felony lawyers. They're not assigned to a fast-paced sort of, arraignment court. They don't have their own clients. They're not advising for us, they don't do any negotiations. They don't do any client advisements. They work directly with the felony lawyer who the client is assigned to. That felony lawyer can easily tell their client, this person is a PTL and they are working on your case with me under my direction. And so that works just fine because they're operating with such a limited capacity. But if we're going to treat these folk like real lawyers, it'll take some freedom, right? We can't provide the level of supervision that will require them to get our approval for every single action, right? And including that initial advisement. But I think you're right. If we can, our SUPs will ensure that people are doing the right thing. We do have that system in place. So it would work to ensure, but just not have the direct advisement by the head of the central training.
It seems to me what you're raising actually has more to do with the scope of practice that we want to allow these PLLs to practice. I mean, a lot of these similar programs in other states do limit the activities of the provisionally licensed lawyers, or whatever they would call them in those jurisdictions, in terms of criminal practice, limiting the types of cases. I think the last meeting decided not to put those types of limitations on this program, but if I'm hearing you correctly, you may want to do that, or at least do that within your own department.
I'm sure they will. I'm sure they'll put a lot of protective measures in place. They always are on the side of the client's safety. So, yeah. But I also want to be able to advocate for the PLLs, that they be given and treated as lawyers and not be given a second-class citizenship in our office and not be treated like glorified law clerks, which I fear they'll be reduced to that if the requirements are too stringent. They'll either not adopt the program or they'll treat them like, post-bar law clerks.
Cindy, did you have a hand up?
I was just going to say, what about just making a requirement that a firm has to ensure that disclosure has been made, as opposed to putting the responsibility on any one person? And then people can set it, whatever firm, agency, whatever it is, as opposed to putting it directly on the supervisor. And then that kind of goes back to 5.1, that if it's partners, it's heads of an agency, they have to just make sure they're in compliance with the rules, which the rules are going to require disclosure. And whatever that is that we end up saying, as opposed to trying to predict who it should be and putting it all on the responsibility of a supervisor, who we can see it kind of takes different shapes, as Tiffany described.
But it sounds like from the way Terry and Greg have described the other rules that are already in place governing supervision, that you can get rid of that sort of complication if a supervisor who is a designated person does have a process or a system in place. So it's not always that person who's doing it, but they have a system set up at their firm for making sure that it happens. Just like Tiffany would have some supervisor in her office have a system set up to make sure that disclosure happens, and it doesn't mean that that one person is always doing the disclosure. They just have set up a system to make sure that it happens.
So, and this is making my head hurt. It scares me to say this out loud, but what Cindy said sort of made me wonder if we should be talking about, right, if we were trying to make a program that people will subscribe to, do you require the employer, whoever that may be, right, a governmental organization, a private firm, the LA public defender, the employer, to ensure that they have, that they provide a supervisor who meets the following requirements, that the employer provides the notification, et cetera, which would have a completely different declaration than we were envisioning coming to the bar, different than the rest of the MJP programs. The other MJP programs have a specific name of a supervisor. We confirm that the supervisor meets the minimum criteria for how many years in practice in California, et cetera. You know, an alternative is just to say, is to put that onus on the employer to make sure appropriate supervision is provided by attorneys in their firm who have at least X number of years of practice. And sort of whatever the other sort of requirements are that we build today on sort of who would be eligible. But then we would just be getting a declaration from the employer that they will ensure that these things happen. The question is, how do you, you know, there isn't, you know, who's the individual that you know, quote unquote, discipline if there is, you know, an issue with, and I see Terry nodding a little, with compliance with that requirement, because the state bar doesn't have jurisdiction over entities, the state bar has jurisdiction over people. I may be talking myself out of this, but it just, I don't know, maybe something that we need to talk about.
You know, Donna, that's exactly what I was going to say, which is that it sounds, you know, really great, but the issue would be enforceability. I mean, the disciplinary authority runs to the individual in almost all cases. So that's usually where the responsibility is placed.
With regard to that, though, let me make a point. I remember that I was one of the ones pushing for law firm discipline many years ago, and of course the state bar turned that down. Very few places have law firm discipline, so we already know that we're not going to discipline an entity or a law firm or anything like that, a government agency. We already have that issue. And in any law firm, you've got a partnership structure where it's not always clear who's supervising, because in big law firms in particular, you know, someone can bring in the mastodon case and then, you know, piece it out to different parts of the firm, and you have different supervisors. So we've already had that, which is why I think it should just be very general. Supervisor lawyers can be a lot of different, I don't think there's a definition, because it could be, you know, the original lawyer who brings it in, who has a tight control over the case. It could be someone they signed it off to. It could be the lawyer that is the trainer, mentor, who's watching over the person. It can be, so I think we have to make it general so that it's not too onerous. Also, we have to remember, I wouldn't worry too much about the discipline aspect, because even though we don't have law firm discipline, it's not presenting a big problem in discipline right now, and there's ineffective assistance to counsel actions, there's legal malpractice. You know, there's a lot of ways that lawyers are disciplined. They're disciplined more in civil legal malpractice than by the bar. So lawyers are going to be afraid of that anyway, plus their obligations under the Rules of Professional Conduct 5 series.
Angela, you had your hand raised.
Yes, and this discussion is making me now also reassess, I think, I mean, at least from a large government office where you're representing entities, not individuals. I think maybe some kind of hybrid would make sense, at least for like the disclosure to happen from the employer, because what I could foresee, kind of right now thinking out loud, is that it may just be a blanket disclosure, because when you represent state agencies, you don't have letters, you know, for each matter. It's like you're, you know, have longstanding relationships with clients by statute, you're representing clients. And I could see the office, a large office, just notifying, you know, one letter to all the agencies that, you know, now we are going to have PLLs in our office, and you may or may not, and handling it that way versus like on a client by client basis, you know, or a case by case basis. So it's very appealing to me, this idea of some of this responsibility being on the employer, and then maybe designating a, you know, a set of supervisors for a particular individual that maybe then is going to have some additional responsibilities.
Okay, any other comments? It looks like there's some legacy hands up. I can't tell if folks have new. Diane.
Well, I agree with Angela, and as I'm looking through this, it seems like so much of what we're putting on the supervising attorney are kind of HR responsibilities, right? Notifying somebody that that person has moved on, and then I'm not seeing like a lot of just general responsibilities on the supervisor with respect to their day-to-day work with the provisionally licensed lawyer.
We haven't added those yet.
Okay, all right.
Yeah,
So
those are not in there yet. We're going to be discussing those.
okay, so I mean, it does seem like some of it could be handled by the employer rather than putting the onus. I mean, in my case, every bill we write, we've got to go tell our client that we're using a PLL. You know, that's the way our lawyering works for the legislature. Plus, can I ask a dumb question? Why do we say supervising attorney, but it's a provisionally licensed lawyer, as opposed to a supervising lawyer? It seems like we're bifurcating names. Is there a distinction that is used in that?
We can
It's
make it all
confusing.
consistent.
Alliteration.
I agree with you, and we only use the term lawyer in the rules of professional conduct.
We'll change it all to lawyer. So I just keep going back to the point that Terry and Donna have raised, and Greg was nodding, is that it is the individual who is subject to state bar discipline. So even though, you know, I agree the focus is on the employer for large state agencies and the like, but shouldn't there, I mean, there should be a person who is the supervising lawyer who is responsible for it, if not directly to make sure these disclosures happen, to have a process in place that ensures that these disclosures happen.
I will just say I agree with that. I think it actually, we may have a lot of unintended consequences if we suddenly bring an employer or an entity into the framework of this rule, especially since we have the overlay of the rules of professional conduct and the State Bar Act as well. And I would just say by just making it the supervising attorney, we really leave it to the employer to decide how they want to arrange those relationships internally. Right. I think it actually gives them more flexibility.
I agree with that. I mean, I'm the managing partner of my law firm. That imposes on me a whole bunch of responsibilities. I don't do all of them myself. I have structures and departments and people in place who handle it. I don't do the vast majority of it myself. So I think I agree, it does give more flexibility.
We have a motion on the table. We need to deal with it one way or the other.
Yeah.
We can amend it, we can drop it, but we need to deal with it.
I think the motion, though, was inadvertently attributed to Tiffany when she was raising her hand to say, well, that would take us out of it.
The motion was for, I think I made the initial motion, and maybe it was Ruben that seconded it. I forget.
Judge Rodriguez seconded it. It was to have the supervisor be responsible for making written disclosure to the client
at the outset, and it could be by email. So we had like some different components to it. So it was a supervising attorney would do a written disclosure of some kind. It would be at the outset, and that was the motion for everybody's edification.
And it was a written disclosure that they may assign.
Yeah,
their responsibility is just to have the written disclosure made. They don't have to do it themselves personally. They could have a system set up.
Yeah, and it doesn't define supervising attorney, and leaving the flexibility open. It can be whoever is assigned at that time who's supervising. And we don't define, right, Greg, in 1.01 supervising attorney. We leave it open because we wanted it to be broad. It can be anyone in her firm Halen decides to assign. And at the time, a supervisor, if I take on someone for a project that day, I'm the supervising attorney on that day for that project.
But we are going to discuss whether we have eligibility requirements for supervising lawyers. So we'll get to that.
Okay, so leaving that aside, that's the motion. The supervising attorney, written disclosure at the outset, and written disclosure is broad, so it gets Rob Barrett's issue of wanting it to be email or anything like that.
Terry, you have a hand raised.
Yeah, just the issue of at the outset, because I thought it was at the outset or during the representation, because there are ongoing matters that a lot of organizations and firms are going to have.
And that could be addressed by a comment, as Greg was saying. We could make a comment and say, if you have an ongoing, because we have that in statute 6147 and 8, right, about continuing representation, then we could put a comment. If it's a continuing representation, you could do it, you know, when you hire the provisionally licensed lawyer and you think they're going to work on the case, whatever, we could define that in a comment later.
Yeah, so it could be like at the outset of the representation, or when a provisionally licensed lawyer, you know, begins to provide legal services or something like that. But we'll leave it to the rules experts.
Yeah,
How to put that in.
We'll sort of figure that out. We are, it is less common for us to have advisory comments in the state bar rules than in the rules of professional conduct. And so my goal would be to avoid them.
Okay, any other discussion before we call the vote? Oh, and just so folks know about, you know, this, obviously there's going to be a lot of wordsmithing and stuff that goes into the draft rules. And so after the rules experts put a draft in place, this group will have an opportunity to review and comment on it and tweak and make tweaks to it before it goes out for public comment. Okay, Ezra, could you call a vote, please?
Yes. Hyland Chin?
Yes.
Ruben Duran?
Yes.
Rob Barrett?
Yes.
Rupa Bandari?
Yes.
Diane Boyer-Vine?
Yes.
Julie Crisp?
Yes.
Terry Garland?
Yes.
Dolores Heisinger?
Yes.
Jennifer Bacon-Henning?
Yes.
Paul Kramer?
Yes.
Carol Langford?
Yes.
Faraz Moody Villarose? Cindy Panuco?
Yes.
Judge Rodriguez?
Yes.
Angela Sierra?
Abstain.
Philip Talbert?
Yes.
And Tiffany Townend Blacknell?
Yes.
Great, motion carries. Thanks, everyone. I also just wanted to, I'd like to move quickly past G2 and 3 because it doesn't seem like they're controversial. I just think that the suggestion from Diane to move those up into F is a good one, and we can leave it to the rules folks to do that. It then leaves G4 as the only real sort of limitation on practice. And this is with respect to client trust accounts. The rule is to not open, maintain, access, or attempt to open, maintain, or access any client trust account. This, Donna, correct me if I'm wrong, did we decide on this last time and this just memorializes a previously made decision? Okay.
We did, and after we sort of moved through permitted activities, we can, in all likelihood, what'll make sense is to sort of move 4 into permitted activities, but describe it as a prohibition. We'll sort of work on labeling because it doesn't make sense to have that probably as a standalone
Hanging
section
out there. Yeah, okay.
But yeah, so I think we have otherwise sort of talked through G.
Okay. So the next up is permitted activities. And it looks like here, there really is just a broad range of permitted activities. Sort of, you can do everything that regularly licensed lawyers can do. And I don't know if Tiffany or Carol or Terry, you guys who worked on this, want to comment on your reasoning why?
Well, I can start. Just our reasoning was we didn't want to get and Tiffany can add on and everyone else. We didn't want to get into the dreaded, what is the practice of law?
Yeah.
Because the ABA has tried to do that, failed. The Cal Bar wanted to do it, but they never wanted to do it. Nobody wants to do it for many, many, many reasons. And so we decided not to do that. We talked about whether we even wanted to do it because they're lawyers and they can go research what is, there's case law on it, there's the Rudder Group. But then we thought, no, it's kind of nice. A lawyer might have questions about what they can do, and that way we can put something in there. So we don't have to. We threw it out for your consideration as to whether you like the idea. But we didn't want to say what they can't do because then we get into that dreaded area.
Carol, you're talking about the may include but not limited to language, just giving some examples.
In H you're talking about. Yes. May include but are not limited to. Yes.
So let me just put it out there that I think this is a really smart approach. I think that we should give agencies and entities and law firms and the like flexibility, and that where the real protection of the public comes from is these folks are going to be supervised. As folks have mentioned before, there's, the threat of legal malpractice claims or ineffective assistance of counsel claims. Certainly all the other state bar rules involving supervision. And so I think that rather than trying to get into sort of what's permitted and what's not, and we can't possibly think of all the activities that a lawyer could potentially be engaged in, that we really lean on existing structures to provide that protection.
So, and I would just say what Carol and Terry and Tiffany looked at was sort of a series of options from really broad to really narrow, including things like, you need to, things that talked about the supervision of the attorney or the consent of the supervising attorney or agreement of the supervising attorney for doing a deposition, and the client would have to consent to them doing the deposition. Filing any documents, doing dispositive court proceedings, whether the supervising attorney needed to sign every communication, whether the supervising attorney needed to appear in court, be available if the judge required, remotely, personally present, all of those things, and sort of in looking at sort of the level of sort of consent required on an item by item basis by the client and the supervising attorney, the conclusion was it really made sense, as Highland was describing, if we are entrusting the supervising attorney to appropriately exercise supervision, as the rules of professional conduct define that, then we should trust them to do that and make those determinations about, yes, it's appropriate for you to provide legal advice in this case, or no, it's not, that's beyond the scope of what you're capable of doing. Yes, it's okay for you to go to this, calendaring, motion in court, but it's not okay for you to represent by yourself in, the felony proceeding. And really giving that level of discretion to the supervisor in all the instances to appropriately exercise supervision. And that also makes this a more attractive route for both the prospective provisionally licensed lawyers, as well as employers who might be inclined to bring on provisionally licensed lawyers. Highland, I see a couple of hands from Neil and Greg. I don't know if
I couldn't tell if those were old ones or new ones.
Old ones, sorry.
Well, it seems like folks are nodding in agreement. Do we have a motion to accept this sort of no limitations on permitted activities subject to supervision of supervising attorney?
I'll move it. This is Ruben.
Thanks, Ruben.
I'll second it, Rob.
Thanks, Rob. Ezra, could you call a vote, please?
Helen Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Terry Garland.
I'm sorry, but I lost my connection. Could someone please refresh me on what the motion is?
Yes, we're voting on basically the language that you and Tiffany and Carol put into H on permitted activities.
Yes, thank you.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Laraz Moody Villarose, Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Philip Talbert,
Yes.
and Tiffany Townend Blacknell.
Yes.
Thank you.
Great, the motion carries. So it is 10:30. I would like to take a short break for let's say 15 minutes so folks can get caught up on their emails, and I know there's a couple of phone calls that folks need to catch up on. So we will come back at 10:45 and we will launch into discussion about supervisors, which as Tiffany referred to as what the fish that's on the hook. So I'm excited to have this conversation. All right, thanks everyone. Be sure to mute. Okay, let's get back into our meeting. Looks like folks are coming back. So to get everyone oriented, we are now going to start our discussion of requirements for eligibility to participate as a supervisor. And that's not included in the draft rules you received because we still have not made any decisions on it yet. They instead appear starting on page 13 of the memo. It looks like there's no page number on that particular page, but there are page numbers on the pages around it. So if you go to the end of the charts end at page 12. The very next page, page 13, is eligibility to participate as a supervisor. Okay. So the first three are really posed as the first three bullet points. Sorry, the first four bullet points are posed as declaratory sentences because they did strike me and the state bar staff as relatively non-controversial. So the first bullet point is that a supervising attorney shall be required to practice law as a full-time occupation for at least 4 years in any U.S. jurisdiction. And after practice
I
law.
don't see this. Where are, I can't find it in what you gave me. I don't know where we're looking.
Okay, so we're looking at the memo that we were looking at last time, the memo that we used in the last meeting.
Okay. I'll find it. Thank you.
Okay, so we're looking at page 13 of the memo from the last meeting. Page 13 is the first page that begins after the chart. So the first bullet point talks about how long somebody has practiced. The second bullet point talks about can't be inactive, or ineligible to practice or have been disbarred. The third is about having practiced in the same practice area, and fourth is working for the same entity. I don't know if folks want to take these separately or all together. Diane, go ahead.
I think we should take them separately. I just have a question. What do we mean by full-time occupation? Does that mean a supervising attorney who's been working part-time for an organization, or just means you're only a lawyer and nothing else? I'm not sure what that means.
This is in the state bar's multi-jurisdictional practice rules, and so I don't know if Donna, you want to speak to, or if someone from the state bar could speak to this, because this is just taken from the MJP requirements, right?
It is just taken from the MJP requirements. I didn't see Amy or Audrey. I don't know if Selena is on the call and wants to talk about how that's been interpreted for the other MJP requirements.
Sorry, this is related to the first bullet on the supervising attorney.
Yep, having a practice law as a full-time occupation.
Yes. So you have to have been an active California attorney for the past 4 years. And you see Selena is on as well. And that is a requirement. I think if the question is, how do we verify that? Selena, are you on to help answer that question?
Selena is an attendee, so she needs to be elevated to panelist.
And Amy, she's actually on a call at the moment.
Okay.
Okay, so yeah, and Diane's specific question is, what does it mean to have practice law as a full-time occupation?
Yeah, I think we should wait for Selena on that. I'm not sure how we interpret that. I do know that we, review the supervising attorneys registering as as an attorney with the California State Bar. So could we go on to the next question? We'll come back to this.
Great. Any other discussion on this first bullet point about how long a supervising attorney has to practice?
Are you saying how long or full time? Because full time, you can't say that. I mean, you have people like me who teach and practice. So practice full time. I don't really practice full time because I also teach.
So we're waiting for Selena's interpretation of this because it is from the MJP rules. Tiffany?
And also the immediately preceding piece. So if someone's out on paternity or maternity leave, does that disqualify them if they were recently out for 6 months because of childbirth? Or is that an exception to the rule? Or
That's a good question.
Yeah, I doubt that that time gets included because I think we look for somebody being active. But again, let's have Selena confirm that. Sorry.
Yeah, I think that's a status issue, active status. As opposed
Just
to
active status licensed by the bar?
Yes.
Okay.
My hand is up.
Rob.
It's Rob. Where I understand that 4 years comes from the NJP and other places, but why 4? It's kind of a rhetorical question because I have directed the legal externship program for law students for 30 years over time at 3 different schools. We've never had a particular number of years required in practice, and also in 30 years I've never gotten a complaint, and the bar's never gotten a complaint. And we have lawyers more junior than that supervise law students. I'll go out on a limb here, and I'd like to see that year requirement come out entirely. It's arbitrary, and it's going to exclude some people who are other. We're not going to have. Are we going to have thousands of provisionally licensed lawyers? How many are we going to have?
We could.
That being the case, I think we ought to make this as broad as possible. Once you've got your law license, argue before the United States Supreme Court. They're going to be on the hook. The fish are going to be on the hook. I say take this out.
Well, I think one of the questions I would pose is sort of, is there a reason to deviate from the sort of longstanding rules that we have on this for this particular program? So to the extent that this is the requirement for those who are already attorneys licensed in other states who are acting as registered in-house counsel, acting as registered military spouse attorneys, is there a reason to make the requirement lesser for a supervising attorney over someone who has not yet taken or passed a bar exam?
Oh, why don't you have it for law students then? They're even less qualified.
Amy, what's the requirement for PTLS?
Yes, I'm pulling that up right now. Sorry about that.
So while you're looking that up, I just would point out, I think the reason why you have this supervision requirement with at least 4 years experience is, I think, as we all know, unfortunately, law school doesn't necessarily teach California law, right? And so if you graduated, you may not know California law, and the hope is that by having a supervisor that is familiar with and experienced with California law, that helps negate that, that knowledge gap.
Well, as long as I started this fight, California now tests on California law, and once you get your license, you are deemed competent in California law, whether they've asked a question about it or not in the 4 or so subjects that test on both.
But this license is supposed to be a stopgap for folks that maybe can't study for the bar exam right away. So I agree with you about that. Of course, there are topics now that test for California law, but again, this is meant to be a very flexible program for those that can't take a bar exam.
So I have the requirements for PTLS supervising attorneys. They have to be a licensee who's active and has practiced in California or taught in a law school as a full-time occupation for at least 2 years before supervising a certified law student. And I also think that the rationale behind the 4 years experience is that this person serves as kind of the guide for somebody who, for MJP at least, for somebody who is not familiar with California law. So the more experience that person has, I think the easier it will be for that, for the incoming, whether it's registered in-house counsel or registered military spouse attorney that's coming into California.
Well, I'm making progress. We're down to 2 years with the PTLS. I don't know how many votes I'll get for that, but if it's good enough for PTLS, why shouldn't it be good enough for this?
I guess I'm kind of with Rob in that. I say kind of only because it's a little funny here that we have 2 years in one place, it sounds like, and 4 years in another place. And now we want 4 years, or we have 2 years in one place and we want 4 years. I'm still confused on that. But it seems to me overall that we really want to be broader and let the firms and agencies deal with that and define it themselves. Because the more we try to micromanage this, the deeper the rabbit hole I think we go into. Because Rob's right. I have clinics at USF and they're law students. I mean, they do a great job. You have all kinds of different requirements of the years. So to me, it's up to the supervising attorney. And that attorney, whether they're 1 year or 5 years, you know, they're on the hook. They're the fish. So I think we have to be careful of putting too many restrictions on number of years or anything else on them.
I do want to highlight, though, some of the prohibitions for PTLS. So, for example, the activity that's permitted for PTLS students, also under the direct and immediate supervision, it has to be in the personal presence of the supervising attorney, which I think is different from what we just decided for the provisionally licensed attorneys. They also have to obtain a signed consent from the client on whose behalf the certified law student acts on. And also there is, yeah, that oversight required from the supervising attorney.
So I noticed Selena is with us. Selena, we had a couple of questions with respect to supervising attorneys and the number of years they need to have practiced before. We're looking at the requirement from the MJP rules, and there were a couple of questions. One is, what does it mean to have practiced law as a full-time occupation?
Well, basically, the attorney has to confirm that they meet the requirement and have practiced law, basically admitted to the practice of law for 4 years, 2 of which have to be in California, and they also need to confirm, and we verify that through our system.
So does somebody who, for example, teaches part-time and then also represents clients part-time qualify as full-time occupation?
Yes, as long as they have been admitted to the practice of law, yes.
So it's really just whether they have an active state bar license?
That's correct.
So the reference to full-time is not something that you look at in determining eligibility.
No, so it's basically the practice of law, and they will confirm that through the declaration that they complete.
So that suggests to me that's something that we need to revisit in the other programs, because I think it's confusing that language exists and we're not doing anything about it. But in light of the fact that we are trying to lift here the same requirement, if we are not applying it, then it would make sense to take that limitation off in this language.
Okay.
And then same question, which I think Donna already answered, but just to confirm with you, Selena, if a supervising attorney has been on parental leave for the birth of a child, for example, for some period of time, that so long as they have an active bar license, that time of parental leave doesn't disqualify them from
That's
this,
correct.
right? Okay.
And then Selena, if you could confirm for the MJP programs, we require 4 years of total licensure, 2 years immediately preceding in California. And for the PTLS program, it's only the 2 years?
Yes.
I'm wondering how this will affect somebody like Tiffany. Are all the people in that extensive food chain that Tiffany talks about, in terms of the year requirement, are we going to make a decision about that?
So can I just say that my reaction to that is, again, the same way we've been discussing how supervisors can delegate subject to the existing state bar rules on supervision. I mean, I delegate things sometimes to a first or a second year attorney to supervise a summer associate, for example. But I'm still ultimately the one on the hook, but I'm the one who makes the judgment as to whether I can delegate something to a first or second year attorney who can then in turn supervise somebody else. And so I would think that so long as the person at the top meets these minimum eligibility requirements, that they can then decide what systems and processes to put in place appropriate to whatever's being done.
Well, you're going to eliminate some small firms. I don't know if you want to do that. They don't have that kind of structure.
Well, so long as that small firm has somebody who's practiced law for 4 years, I feel like that, we might be eliminating a small firm who has a lawyer who's been practicing for 2 years who wants to bring on a PLL.
Do we want to do that? I mean, I don't. It's not a rhetorical question. I do not like that limitation. Lawyers on the hook, they're licensed, and that's the model we've been using.
Well, I would argue, Rob, that it's not just the lawyers on the hook. The question is, are we ensuring appropriate public protection for those people who get the service of the provisionally licensed lawyer, and having a sort of a 4-year in overall practice requirement doesn't seem so onerous, in that, you know, we are ensuring that the provisionally licensed lawyer is getting the supervision of somebody who does have experience practicing law in California, does have you know, has, you know, sort of touched you know, a variety of different things in the practice area, is, you know, I think I personally find it concerning that it would be if there was somebody that was, if there was a supervising attorney that had a very short time as an attorney. I think it's the same reason that we're not, that one of the things that we are not talking about is allowing provisionally licensed lawyers to hang on a shingle and practice on their own, or just practice with other provisionally licensed lawyers. That there needs to be somebody there who has the experience that can direct them.
Well, I'll say one more thing and then I'll shut up. And that is, I read the discipline reports. I never see people getting in trouble in practice. If for a year or two, what people get disciplined for, they're long-term practitioners who've lost their way. I just don't see it in the junior practitioners. They're usually super paranoid and super careful. And I just don't see it. Now, I promised I wouldn't say anything else. I'm probably lying, but I'll try my best.
Rob, I'll just add a little bit to that, and that is that I am actually on the 4-year bandwagon. And I am because when I look at my students in my classes, and I don't care if it's at Bolt or Hastings, you know, any of that, they're still unseasoned. They're still young, very bright, but still unseasoned. And I think the 4 years is good. And with regard to the discipline level that you're seeing, or the discipline of younger attorneys, I get them mainly, I would say, if I'm going to get a younger person, and I do get them, it would be for competence. That's mainly what they get in trouble for, because they are young. I think the problem you could have is if you have a younger attorney trying to have a PLL, you could get these young, bright, entrepreneurial types 1 year out that want to get them and maybe pay them less, and they take on too much because they're excited and young. And I think that's a public protection issue. If you make them have a few years of seasoning, they're going to know the ropes a little more and realize what they can and can't do. So I would say it's better to have some seasoning.
So it looks like Jennifer has a hand up, and also Diane.
There's good arguments on both sides of this, but I think I tend to agree with Donna that I sort of feel like we would need some compelling reason to diverge from the MJP program here, you know, to differentiate between these lawyers and reduce it from the 4 years. And I'm not sure that I hear that in terms of these provisional attorneys, and that they're so different from the MJP that we would diverge from what's in existence already. And, you know, it is true that when you are sworn into the bar, there are some limitations on what you can do. For example, to be at the United States Supreme Court, in that bar, you need 3 years of practice. So, you know, it's not unreasonable, I think, to decide if you're going to be allowed to practice virtually without limitation, other than being under the supervision of another lawyer, that we should impose the same standards that exist for the MJP program, and similar to what is required to even argue a case in front of the United States Supreme Court. I just don't see a compelling reason to diverge from that for this program.
Okay, Diane, and then Neil.
Yes, not just echoing what others have said. I support the 4 years, and the other aspect besides public protection, which is important, is kind of the mentorship aspect of having somebody who's a little bit more seasoned. You know, you can argue is 4 more, that much more than 2, but in my mind it is. And so I would argue for the 4, both from public protection and for, you know, somebody who's a little bit more seasoned and able to mentor the provisionally licensed lawyers.
Oh, Neil, did you have something?
Yeah, well, actually, I think Greg and some other folks had their hands up before me. So just flagging that. But really quickly, if you're talking about numbers, about how many folks we're cutting out, this is just a very rough calculation, and the admissions folks can correct me, but I think there's about 200,000 plus active California attorneys, right? And if you look about the yearly admission to the bar, it's about 4,000 attorneys every year. Multiply that by 4, that brings you back to 2016. We're talking about maybe excluding about 15,000 or so attorneys as being not experienced enough out of a pool of 200,000 plus. So.
Greg?
I think I don't want to reiterate what everyone's already said. I would just say, make 2 observations. One is that Mark Tuft, who was on our Rules Revision Commission, often would come back to, and I thought it was really helpful for me as I got that master class in legal ethics over a 2-year period, which is the rules of professional conduct in the State Bar Act. It serves a couple purposes. One, it provides the standards by which, if you violate them, you're subject to discipline and perhaps loss of your license. But that's not the only function of them. It's also to instruct the profession on what is expected of them. So the fact that a lot of younger attorneys are not subject to discipline, there may be a number of reasons for that. One, it may be that their supervising attorneys keep redirecting them from making the violations that would subject them to discipline. So it may be actually supervision working. The other thing is they probably are more well-versed in those rules because they just went through the NPRE and law school. And so they may actually know those rules a lot better than, especially these new set of rules, than older attorneys who tend to forget because a lot of people don't stay up on legal ethics. The only thing the last thing I would add is this is really just, it's a policy decision that ultimately will be made by the court. The court's already made the policy decision on the multi-jurisdictional practice rules. And so that should probably inform your decision-making around some of this. I won't speak for the court because I haven't considered any proposal, but I think it would give them pause to think that a first-year attorney would be supervising a provisional licensed lawyer. And that's all I'll say.
Okay, any further discussion? Do we have a motion?
I was going to make a motion that we approve the 4-year rule.
So the 4 years plus 2 years in California, and 2 years in California is written in the first bullet point?
Minus full-time occupation.
Right.
Okay, minus full-time occupation.
Good.
I'll second it.
Second from Diane. Ezra, could you call a vote, please?
Hyland Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
No.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Chris,
Yes.
Terry Garland,
Oh, it looks like she's frozen.
Okay.
Yeah.
Okay, I'll come back. Dolores Heisinger,
Yes.
Jennifer Bacon-Herney,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Faraz Moody Villarose, Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Abstain?
and Philip Talbert,
Yes.
and Tiffany Townend Blacknell.
Yes.
Thank you.
Great, the motion carries. So next up is the second bullet point. As written, it says a supervising attorney must not be inactive in California or ineligible to practice, suspended, or have resigned or been disbarred in any jurisdiction. This is just straight from the MJP rules. The one difference is that with respect to other states is that some states provide that the supervising attorney may not be subject to discipline or have ever been or may not have been ever disciplined in any other jurisdiction. So this does not include that more stringent requirement. folks want to discuss?
What about if they have a pending disciplinary matter in another state or a pending one in this state that just hasn't yet been, or what if they're in the investigatory stage, so it hasn't gotten to an order to show cause? They're not yet a respondent, but they're in the investigatory stage. I'm not sure I understand how this would apply to those people. Do they actually have to have a discipline record? If so, all the people that are in investigation now or in a respondent then can still supervise?
Seems like my read of this is yes, but Selena probably knows the answer.
Yes, so the result has to be that it results in disciplinary action.
Okay, so we have to think about that because there are a lot of complaints that go to nothing. I mean, I represent lawyers before the bar, seen them. Some of them go to nothing. You can have people, you know, sometimes in prison complaining about their lawyer. That doesn't mean the lawyer was bad. But you also get some that do have merit, and some against attorneys that have substance abuse and those types of issues. Now, what we could do is, if it's still in the investigation stage, obviously, let it get investigated. It doesn't count. But if in order to show, you know, if you have a pleading, if they filed something in the state bar court, that means the bar is going after them. So I'm not sure how we want to address that.
So one of the things that I think we also need to remember is that until a complaint has been filed in the state bar court, complaints that we receive, investigations that are ongoing, are entirely confidential. And as you said, right, we get 17,000 complaints a year. A very, very, very small percentage move on to actual discipline. Some certainly have warning letters or resource letters, which isn't in and of itself discipline. So that, you know, that's certainly something to consider. You know, one, do you want to hold sort of pending complaint, which could take a year potentially to resolve, against a supervising attorney and prevent them from supervising? Or do you just want to say, if they've been the subject of discipline, and you could also choose to expand that to non-disciplinary actions like warning.
Don, I got an idea, because we have in 60680, section O, where you report actions of the Business and Professions Code, we say that what you have to report is if you've gotten disciplined or if you have 3 or more legal malpractice cases in a year. So those are the kinds of things that kind of play into this a little bit. So that would make it where it would be okay if they had a pending investigation or even a legal malpractice case against them or 2. So we have to think, if we're gonna, you know, vary in a way from, by reporting, I mean reporting to the state bar. If you have 3 or more malpractice actions, you have to report to the state bar. If you have a felony or misdemeanor, that's moral turpitude, the misdemeanor has to be moral turpitude, it has to be reported to the state bar. Or a fraud action, we already have that's in the Business and Professions Code. So it's something to think about, but it would go along then with what you're saying, in that if it's just in the investigation stage, you wouldn't have to report it. So we have to think about, as a policy decision, how we feel about that.
You know, maybe I'm wondering why not be consistent with the MJP rules on this. I mean, this is a policy that has been reviewed previously, and a decision has been made. And I mean, it seems like a good analog to this one.
Yeah, and that's the language that we had proposed in the bullet, was the language from the from the MJP rules, and so just pointed out that some states have some more stringent requirements. Those states' MJP rules may have those same stringent requirements. That I don't know. We didn't do that piece of the research, but that could be an explanation for that difference as well.
Well, and we're not exactly MJP totally, because you can have an MJP lawyer from Arizona who's been practicing 10 years that wants to be a California bar lawyer. You can have a registered in-house counsel from somewhere else. So we're different. We are just graduating law students and supervisors, you know, who are going to be supervising them. So that's it's slightly different. And so I think we have to kind of figure out whether it matters to us. And we might want to say no, just leave it broad, whether the supervisor attorney is in any kind of trouble that has not yet risen to fruition of see, they could be before the state bar on 5 different cases under that law, but there's not a decision made yet by the bar judge, or it's under the review to the review department, and they can supervise. If we want to say that, then okay. But we just have to make sure we think about that, because that's what we're saying.
And so one of the things I would just point out that we had put in the draft rule, I think, let's see. In the draft rule that we had lifted from the MJP rules, had to do with the termination. Let's see. And we basically say that if there is a sanction for misconduct against the supervising attorney, then the provisional licensure would terminate. So at that point, right, if there'd been pending discipline, and it ultimately gets, in fact, discipline is meted out, then if we were to follow the MJP rules, then that would be the time at which the provisional licensure would cease.
Okay, and sanction is defined broadly, or narrowly, it sounds like. So it's discipline by a state bar court. It wouldn't be a civil court giving extreme sanctions or anything, right?
No, we talk about sanction for misconduct by the State Bar of California.
By the state bar, okay. Okay.
Other discussion? Folks comfortable with this provision, want to move it?
I guess I'm not entirely comfortable if they would have a big state bar action pending against them and they could still supervise a provisionally licensed lawyer. But I don't want to, if no one else is willing to jump on my bandwagon, then I'm fine. I just am uncomfortable because I have, I represent some of these people sometimes, and I see them with so many cases in the bar, 7 instances of failure of competence, and they're going to eventually get disciplined. So I know they'd be the best supervisor. But again, if you think about it from a due process perspective, maybe they haven't yet been found to be incompetent.
Presumption of innocence, Carol.
Yeah. If you were inclined to split the baby, the way to do that would be, unless there has been a notice of disciplinary conduct, basically the complaint filed against them in state bar court, right? So that weeds it down from the 16,000 complaints to 600 in which an NDC has been filed. So at that point, the Office of Chief Trial Counsel at the State Bar has determined that they believe that they have clear and convincing evidence of misconduct. That would be a way to split the baby if people are uncomfortable in the way Carol is. If not, you can, as Terry was suggesting, leave the rule the way it is in the MJP rules.
You could also add further splitting by saying that the charges have to possibly result in either disbarment or some level of suspension. right?
That I like, because you can get actions that don't have a lot of merit that the bar is pursuing. We've seen a lot of that sometimes. And if it's serious misconduct.
I'm going to publicly dispute that comment.
Okay, no, but I mean, you know, sometimes you get minor things and default, you get all kinds of things in the state bar because you get all kinds of lawyers. But you're right, but that's hard too, because, you know, you'd have to say something like, well, we have disciplinary standards, we do. And they say in them, for this type of misconduct, here is the range of discipline. And I helped draft those standards, 3 or 4 years ago. So we could look at those for the serious misconduct. We have standards for serious misconduct. We do have that already in the standards. If you wanted to split the baby, we could do that.
Someone make a motion.
I actually would just move the current language, see where that gets us.
I'll second.
Kylan Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
A reluctant yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Abstain.
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great. So on the third bullet point, this talks about whether a supervising attorney needs to practice law in the same practice area. And this says a supervising attorney must currently practice law in, or within a reasonable period of time, have previously practiced law in the specified practice area in which the provisionally licensed attorney will be practicing. Discussion? Objections?
Does this also come from the MJP criteria?
No.
It does not. This is not from MJP. This is just one that we had thought of. You know, from a public protection perspective, we didn't like the idea of a tax lawyer supervising a lawyer practicing immigration law, for example. That's where it comes from. Rob, did you have a comment?
Yeah, I don't like the word reasonable in here, and I don't like the limitation. What if a lawyer wants to go into a new area? This is what provisionally licensed lawyer might be a good, cost-effective way to do it.
But how does that lawyer get meaningful supervision?
Paul, say that again. It was hard to understand you.
But if the supervisor is just learning, I don't see how that helps the PLL.
I just foresee enforcement problems with this. Is the bar going to be looking into this? Is that who we put the burden on?
I think we require that the supervising attorney certify this in their declaration.
You have a hand from Jennifer Henning?
I guess I'm just curious too what the breadth is of the practice area. So for example, in county government, right? We do everything from property tax law to child dependency to land use to general contracts. I mean, it's all public agency law generally, but it can cover such a wide variety of things. And I can certainly imagine in an office, like in a county counsel's office, where you have one or two senior attorneys who are designated the supervisors for these lawyers, you know, generally in the area of county government and public law, but I don't know that the day-to-day they would necessarily be practicing on any particular, you know, department area that law student might be in. So I guess if we just sort of have a general understanding of the practice area, or does it get down to, you know, very specific cases, you know?
Is litigation a practice area? Are transactions a practice area?
Right. I mean, I definitely think that there's a need for meaningful supervision. So in concept, I understand the criteria and I do think it makes sense, but I think in practice, especially in larger offices that, you know, cover a wide variety of subject matters, and thinking about public agencies like the ones that my members work in, it just gets a little tricky to understand.
So in part, what I hear Jennifer saying is, in lieu of saying they must currently practice law in the specified practice area, that they need to assert that they, I was trying to remember your precise language, that they can exercise meaningful supervision in the practice areas that the provisionally licensed lawyer will be assigned.
Yeah, I mean, I think that's what we're trying to get to, right? And I don't think any of us disagree with that. It's just a matter of how you would articulate it in a rule that the supervisor understands what they're on the hook for and that the bar could enforce if it needed to. I don't have great suggestion here for how to accomplish that, but I guess as worded, I'm a little concerned, especially for agencies like the ones that I represent, where it's really multidisciplinary. And yet, you know, you'll probably have supervisors that maybe did dependency cases 10 years ago, but don't necessarily do that practice area. That would, you know, they would be the ones designated as a supervisor.
Well,
I don't know.
One way to get at this is to just do away with this separate requirement and to lean on the fact that the supervising attorney must agree to assume professional responsibility for any work that the PLL does. And that's the way that PTLS and the MJP rules do it. And so I think that just puts the onus on the supervising attorney to make sure that they are ready and willing to take on that professional responsibility for the PLL's work, which sort of assumes that they do have the ability to, as you say, Jennifer, meaningfully supervise. Angela has a hand.
Yeah, you know, what if sort of a middle ground, if we just took out the word specified and make it general practice area, and then in the declarations, whoever's going to do the declaration, I guess it's the supervising attorney who can then designate things, can define in there how they are defining the practice area. And I do think for some practices, it's going to have to be very general. If it's government law, you know, you get novel questions, novel areas that maybe a section has not really dealt with for a long time, and they're going to have to get up to speed very quickly. But at least, you know, we would be providing the PLL with someone who can be a mentor, at least generally, whether we're defining it as litigation practice or appellate practice or more a substantive area, like it could be, you know, government, civil government practice. So that may be a middle ground.
Halen, I liked your idea of taking it out and putting the onus that it's a professional competence issue, professional responsibility issue, and not try to micromanage this.
Craig had a hand raised and then Rupa.
I was just going to make a suggestion again. You could also just make a more direct reference to the rules of professional conduct, Rule 1.1, that the supervising attorney exercise competence in the areas of law in which they are supervising their PLL. Something along those lines, just to underscore the fact that we don't want supervising attorneys directing the work of PLLs in areas in which they are incompetent to practice themselves.
Okay, Rupa?
Yeah, so Greg's suggestion works for me. Otherwise, I was going to say taking it out is fine. And I just wanted to ask, so am I understanding correctly that we're going to make the supervising lawyer, I guess we're calling them, certify a bunch of things in a declaration of some kind? Because if we're doing that, my suggestion would be that something like what Jennifer was saying about meaningful practice, meaningful supervision could just be in there in the declaration and leave it out of the rules here. So either Greg's suggestion of going with the professional rules or taking it out here and putting it in the declaration under meaningful supervision would be my suggestion.
I like the idea of referring in the declaration to an existing rule, because that existing rule will have, already been subject to interpretation and stuff like that. So what if we take this out and just say that, and have that reference, as Greg suggested, to Rule 1.1, which would apply in any event.
I'll move that.
Motion from Diane. Is there a second?
Second.
Second from Rob. Ezra, could you call a vote, please?
Eileen Chin,
Yes.
Ruben Duran,
Yes.
Rod Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Carrie Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Hinning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Abstain.
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great, motion carries. So last bullet point now on page 13 is, do we want to put a limitation on the number of PLLs a supervisor may supervise? There are some states that include a specific limit. The MJP rules do not. The PTLS rules do have some limitation. My concern about putting a limitation in is the sort of issue that Tiffany raised before of, you're going to have one person at the top, but they're going to be potentially supervising a lot of folks. And my concern is that putting a limitation on it may make it difficult for employers to want to hire PLLs. And you've got the limitation already is, you have to be able to provide this meaningful supervision because these folks are professionally on the hook. So that kind of limits how many people you could competently supervise, I think.
Just to elaborate on that, the existing rule on supervision provides that anybody who any lawyer who directly supervises the work of another has that responsibility, but they don't put any limits on the number.
They don't, and I think, again, because I'm for less, particular requirements on the supervisor, I would say we would not. We want to make it more general. I think they can supervise as many as they feel they can and do it competently. They're on the hook. They're going to have to do it competently or they're going to have a problem. So I think I feel comfortable with the public protection aspect of not putting a number.
We are actually dealing with this very issue with the PTL program as we speak in our office because the previous recruiter hired 35 or 40 post-bar clerks, and we could only supervise 25 under this PTL program. And so we're going to have a situation where 15 or so of the post-bars cannot participate in the PTL program. When our office is of 700 plus lawyers, we could easily supervise each one of them. But because of the limitations placed on us by the program, we're sort of at a disadvantage. So I would, of course, vote for no restrictions.
Ruben, you had a hand raised.
Yeah, I was just going to make the motion. It sounds like most folks are on board with this unless someone has a thought.
I second it.
Thanks.
Okay, any discussion? Ready for a vote, Ezra?
Eileen Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp, Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great, motion carries. Okay, we're now on page 14 of the memo. The first bullet point on page 14, it's the last bullet point that deals with eligibility of supervisors. And this one says a supervising attorney must be prepared to assume personal representation of the provisionally licensed attorney's clients in the event of suspension or termination of provisional status. This is really common in the rules from other jurisdictions. I will just note that I think there is a little ambiguity in here that we'll just have to clear up in the rules drafting, which is you could have provisional status that's terminated simply because somebody passes the bar and gets regularly licensed. So we just want to make sure that it doesn't apply in that circumstance, but I would leave it to the rules drafters to clear that up. I think what we mean here is suspended or terminated as some form of like discipline or there's something wrong.
Could we put it in terms of the PLL's inability to continue the representation?
That's a good suggestion. Rob?
Yeah, like if they get sick.
How about something like if the PLL is unable or ineligible to continue the representation?
That sounds good.
So with those kind of proposed changes that the rule makers can look at, I would move the concept.
Second.
Great, and a second from Paul. So motion from Diane and a second from Paul. Ezra, could you call the vote, please?
Yes. Eileen Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great, motion carries. Okay, so for folks, for planning purposes, I think we will go for another half hour and take a break at 12:15. How does that sound to folks? Okay. All right, so now we're going to move on to supervisory requirements. We're on page 14 of the memo. The first bullet point is really one that we've just been discussing this whole time, which is that a supervisory attorney must agree to assume professional responsibility for any work that the PLL does well, under the supervising attorney supervision. Objections?
I would just note that the two things under that look like new bullets are in fact further explanations of the same point.
Is there, so the way that this is worded, Donna, is for any work that the PLL performs while under the supervising attorney supervision. The other rules that you have listed there for comparison just say under this rule. I don't know that there's any meaningful distinction, and I guess I would just leave it to the rules drafters to make sure that, you know, choose whichever language is better. But I think everyone agrees on the concept. I wish we could do this by acclamation, but because we are doing this by Zoom, we do have to do a roll vote. Oh, and I guess a motion and a second.
So moved.
Second.
Great, moved by Carol, second by Ruben Duran. Ezra, could you call a vote, please?
Eileen Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Chris,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great, motion carries. So Donna, am I correct that the next bullet point, the two bullet points that follow really were explaining that? So then we're now on page 15 with respect to the malpractice question?
You got it.
Got it. Okay, so we are on page 15. The first bullet point that appears, it's in the middle of the page. At least 3 states address a malpractice insurance requirement. So the question for this group is, do we require malpractice insurance of PLLs or require that their supervising attorney provide it? There is currently no malpractice insurance requirement for licensed members of the state bar.
But is there a requirement to disclose if one does not have malpractice insurance?
Yes.
Yes.
And just to add on to that, there's a requirement if you did not disclose because you had malpractice insurance at the beginning of representation, and then subsequently you lose coverage or you don't, then you have to notify your client at that point.
So clients are protected.
In writing. In writing.
Yeah, in writing. I think we're okay on this.
Okay, any discussion? It sounds like folks are, with the existing rules in place requiring disclosure of no insurance or loss of insurance, are folks okay not imposing a malpractice insurance requirement here?
Yeah, I'll make the motion that we do not require malpractice insurance and rely on existing rules for supervising lawyers.
I second it.
Great, motion from Ruben Duran, second from Carol. Ezra, could you call a vote, please?
Eileen Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Chris,
Yes.
Terry Garland,
I have to abstain on this one?
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Abstain?
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great, the motion carries. Okay. The next topic on page 15 of the memo is what level of supervision is required. Various jurisdictions in their similar program require certain things. So the first one is with respect to court appearances. Must a supervising attorney be present at all court appearances in which the PLL appears on behalf of a client? Must they appear in person? If that is how the PLL is appearing, or is remote appearance permissible, or must a supervising attorney only be available to appear upon request? I think it's tough given the varying natures of why you might be appearing in court. I would be comfortable sending a brand new lawyer into court for a calendaring conference, I think, but not so much for a summary judgment motion or felony trial. And so on this one, I'm kind of inclined to leave it to the supervising attorney to make the judgment call. Diane?
Well, I kind of like what Montana does, which might fulfill what you want, because it requires the client to consent to your not being there, and we'd have to talk about what that means, but it does give some protection in criminal matters, and I don't practice in these areas at all, so perhaps I'm talking outside of my area where I should be speaking, but you know, you might even combine Arizona, right, where it's in some of the criminal matters at a higher level, like felonies, you would have them appear.
I agree with Halen in that I don't think we should say anything about it, because then you go down the rabbit hole of different areas of practice and immigration deportation hearing, this or that. And then you have problems with big public agencies not able to always have someone available, which then the program's gone for them. They're smart enough to know how to handle the felony trials. They're not going to put a first-year lawyer without a license in a felony trial.
Yeah.
I think we have to trust the judgment of the supervisors on this.
Do we know what judges would want?
I can chime in on that. I do think that, well, my experience has been that typically in criminal practice, there are lawyers that are assigned to a particular department, and that department is headed up by a supervisor from the DA's office or the public defender's office. And the previous comment is absolutely right. You're not going to give a first-year lawyer or a PLA a felony jury trial involving a serious or violent felony. That's just not going to happen. So I do think that there's a level of oversight there from the supervising member of the DA's office or the public defender's office. And you also have the oversight of the court. I personally, if I felt I was concerned about the experience or the level of representation from a young attorney or a provisionally licensed attorney for that matter, I would probably say something to the supervisor about it. So that's my take.
Great, thank you. Any other discussion?
I agree, of course. I think that they're in the best position to know the complexity of the matter they're handling, and there could be situations where we would have a PLL do a calendar matter for a felony, continuing a case, trailing a case for prelim. And so I don't think that they would need to have a supervisor on hand to do that. So yeah, I would agree to leave it into the hands of the supervisor.
And I would say that's really consistent with what we were talking about when we were broadly defining what a PLL can do, and that we really were sort of saying we're going to leave it up to the supervising attorney to exercise their responsibility as a supervisor to ensure that they are assigning the right level of work and assigning the right level of freedom, attending court when they should be attending, not attending court when they don't need to, And it also goes to the issue that Judge Rodriguez mentioned, he'd reach out to the supervising attorney, which goes to the question of the issue of why we would specify that on the pleadings. You need to specify the name of and the contact information and bar number of the supervising attorney.
Makes sense. Do we have a motion for not imposing express limitations on presence of supervising attorneys at court appearances?
Well, just a quick second here. So I'm noticing on pages 17 and 18, I think also Greg had his hand up as well, but on pages 17 and 18, I'm noticing that most of the states seem to have some sort of requirement of the supervising attorney being present. And I'm not sure, it sounds like I see a lot of asterisks, so it sounds like there's different rules maybe. So I don't know if Arizona, Montana, and Colorado represents the entire universe of different approaches.
Sorry, I did not have my list of panelists scrolled up, so I missed your hand. I'm sorry about that.
And Greg had his hand up as well.
Okay, Greg?
Mine was a legacy hand, actually.
Okay.
Neil made my point because I was looking at that as well, that it seemed that most seem to have some sort of restriction, and then the asterisks makes me want to look deeper.
Yeah, and so we've certainly got the rules here in front of us. I think the asterisk applied sort of if there were sort of further explanation, and some of it was, in some instances you needed to be available. You didn't need to necessarily need to be present, but you needed to be available if called upon. In other cases, it was sort of this in criminal proceedings or in criminal proceedings that are less than felonies, needed to be present or not. It really depended on the jurisdiction, and there frankly seemed to be some inconsistency in terms of, some wanting you present, in civil, and some not wanting you, not needing you present in civil. And so, Caroline, I don't know if you've got sort of something that more clearly spells out those asterisks, since you took the laboring oar on putting together the chart.
I don't have a list of the specific requirements for each jurisdiction, but that's exactly what it indicates, is basically depending upon the type of court appearance. And I noticed that it was normally, based upon like the dollar amount at issue. So like in a civil matter involving a certain dollar amount, then the supervisor would be present. A felony criminal case where the stakes are somewhat higher. So it's basically just, most of the jurisdictions, while the requirements are different, consistently follow some structure of, the lower level the appearance is, the more likely we are to just allow the provisionally licensed attorney to appear without supervision. And like, as you get, as the stakes get higher, that supervision would be more desirable.
So my problem with it, so I did take a look at what these states require, and the only thing that I would add if we want to import stuff from these states is really the idea that a supervising attorney would be available to be called on if needed, not physically present. Because my problem with the way in which the states have enumerated it is they've really focused on the dollar amount in civil cases or felonies versus misdemeanors. And that leaves out a whole realm of cases in which people's rights could be seriously affected. I mean, you've got domestic violence restraining orders where somebody's life could be at risk. You've got child custody issues where parental rights could be terminated. You've got deportation proceedings. I mean, there's sort of, like, if we're going to go through our minds and like enumerate all of the matters in which somebody's rights could be seriously affected, that would be really tough. And I would be inclined to leave it to the supervisors to decide. At most, I might add that a supervising attorney should be available to be called on if needed.
Why don't we just leave it out and see what public comment we get? Because my big concern is the DA or public defenders or someone like that or big state agency. They're not going to be able to have PLLs if we say you have to be available for all the cases they process. The supervising attorneys are the fish on the hook. They have to make that decision. I really think we should and some of those states are smaller states. It's a whole different it's easier for them. Their state bar could have one prosecutor. Their public defender could have 5. You know, it's different from us. So I'm okay with them having different requirements. I think we put it out there and see what we get.
Another thing you could do is maybe, and I think I mentioned this last time, is you could have the court make the call, because again, I mentioned before, the court may know these attorneys and know these supervising attorneys in particular, and may have a better sense, boots on the ground, about whether or not the supervising attorney should be appearing as opposed to a PLL. The only thing I'll note too, I totally agree that with DA offices and PDs, it's probably unlikely that they're going to throw a PLL into a felony matter case. But what I'm more concerned with are probably solo practitioners, and I don't know how they will utilize the PLLs. So again, those are just my concerns.
So Neil, how would you propose that I mean, we could just have language that says, you know, if requested by the court, or is Highland's proposal of must be available to be called to appear as needed, sort of accomplishing that same goal?
I suppose you could combine the two, right? As needed or unless requested by the court, right?
So you're saying as needed, then, so the PLO could be in court, and if they happen to need the supervising lawyer, they could call them, who might not be available in the public defender's office. But that's the idea, or they go in without the supervisor, and then if they're needed or the court says, then they can continue the hearing. I guess they could continue.
The second part, yes, yeah. Second scenario.
I would voice a strong opposition to the judges having the say in terms of when to summons the supervisor. I mean, obviously, bench officers have different temperaments, and we deal with a variety of personalities. No offense, of course, any of our bench officers on the call, but I would think that would cause an array of controversy to be at the will of a judge. Have a supervisor at the mercy of a judge who may call them down to handle a matter. It just won't work. I think it should be left to the discretion of the supervisor. And maybe perhaps as a compromise, it could be that maybe they are available, or have one of their designees be available if they're not available for a consultation, but not that it be within the control of the bench officer, and
I
not
think
that
the judge always has, right? Couldn't the judge just do that anyway? Like, we don't have to say anything about it.
They can try. I mean, we have that sort of relationship where there are people who are kind of at war with bench officers, and the bench officer will call up to the office and ask for our chain of command, but they're not subject to them ordering them down. They're not the attorneys of record. And so, you know, it would not be, you know, I just want to voice my objection to that piece.
But in this case, if the supervising attorney's I guess the question is the supervising attorney also attorney of record with the provisionally licensed lawyer, since their name is also on the pleadings? And if so, then going back to your question, Highland, wouldn't the court have that authority to just?
I don't know how. I mean, yeah. I mean, this is a case. It's like a case of we're creating this system. I don't know if that's ever been true. You know, honestly, on all of our pleadings, Ricardo Garcia, he is the public defender in LA County, so his name is on all of our pleadings. And you know, he designates who he assigns to the case, but he's the one that's appointed at arraignment. And if tomorrow he takes me off the case, then I'm off the case. That's within his discretion, and no bench officer can pull me back on the case because they, you know, I guess if they're both on the case simultaneously, maybe they do have the authority. but that would be kind of a mess, especially if we're operating from a system where the supervisor isn't necessarily the one that's immediately available, but they designate someone else. You know, who could take vacation? You have like 35 PLLs. You would have to always be on call. That's ridiculous.
You know, chiming in, and I apologize if this point has already been made while I lost connection. But one of the things is just, I want to encourage folks to step back and look at the big picture perspective on this. The more that we add on these onerous supervising responsibilities, the more likely a potential employer is just to say, look, I'm not going to hire these PLLs. I'm going to, you know, the market for legal talent is going to be competitive, especially as the economy continues to suffer. And they're going to say, I'm just going to pass, and I'm going to look elsewhere.
Here, here, Terry, that's right.
Looks like Judge Rodriguez has a hand raised.
I just wanted to say that I think that Tiffany's concern is valid about being concerned about judges all of a sudden calling in a supervisor at their whim to come in to handle a particular matter. I don't think that you need to incorporate the court into the rule. And I also agree with the last comment that the more of a burden that we put on supervisors, the less likely that these employers are going to want to even go through with the burden of hiring somebody as a PLL if all these restrictions are in place. As a judicial officer, I think it would be a rare occasion that I would ever have to make a phone call to the DA's office or the public defender's office where I had to express any sort of concern about an attorney's competence to come in and handle a matter by an officer. If they're willing to stick out their neck for this person, they're going to do their job. They're going to supervise. I don't think we need to involve the court.
Okay. Any other discussion? Carol, you had a hand raised, but I think that was earlier. Okay.
It's a legacy hand.
Does anyone want to make a motion?
I would move that we have no requirement that a supervising attorney be present at court hearings. Leave it up to the supervising attorney to determine.
Great.
Second.
Tiffany.
So moved.
Okay. I think I lost track of who moved and who seconded, but maybe Ezra caught that.
I missed who seconded.
Judge Rodriguez.
Okay, thank you.
Great.
And it was Jennifer that moved it.
Great. Could you call the vote, please?
Hyland Chin,
Yes.
Ruben Duran.
Yes.
I think you're muted. Ruben Duran.
Yes, I'm sorry. Yes.
Oh, okay. Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Abstain.
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great, motion carries. So the next topic to discuss is the very last sub-bullet point on page 15, and I would propose that we combine our discussion of that with the bullet point that's at the very top of page 16. And both of these go to whether a supervising attorney must review, approve, and sign all documents prepared by a PLL to be filed in court or used in arbitration or a quasi-judicial proceeding. Same with approving, signing, reviewing agreements, settlements, contracts. So I guess one gets to the sort of litigation space and the other gets to the transactional space, whether supervising attorneys have to review, approve, and sign. I see Carol shaking her head no.
Well, I'm thinking about it because I think that's too hard. And I think that's going to be too onerous. Maybe you could say any, like we said, I think we said before, I don't recall, final disposition documents or something that could, you know, a summary judgment motion, maybe a settlement document, maybe those kinds of things. But otherwise, I don't think we have limitations on that because they are being supervised. See, now you're getting into the particulars of what supervision means, which again, we go down a rabbit hole.
Yeah. I think that existing, I mean, the same way that when you're supervising a brand new lawyer in a normal environment, you would be reviewing stuff. You wouldn't let it get filed because it's got your law firm's name on it, or it's got your entity's name on it, or county council, or whatever. And so you wouldn't let it be filed unless somebody looked at it and made sure that it was okay. Rob, you have a hand up.
Well, normally I'm against, you know, these sorts of restrictions, but I mean, now somebody's committing something in writing, either something to be submitted to a court or a transactional document. I mean, all we got to do is look at it and read it once. This is a real question, not a rhetorical question. Is that really too much to ask?
But don't the rules, the existing rules already require this sort of this type of supervision?
Well, yes, but in some circumstances, we've spelled things out kind of as a reminder, where, for example, including but not limited to.
Okay.
I mean, this is not the hill I want to die on, but there's something about just looking at the paper and signing the darn thing before it gets filed and before the client is bound by the contract. I mean, I could be moved off that. It's just a thought.
How does this work? Oh, I'm sorry. How does it work for the bigger agencies, like the bigger?
So Greg, let's hear from Greg, who has his hand raised, and then Jennifer as well.
I just wanted to answer your question, Haleen, about the existing rules. So 5.1 requires a supervising attorney to make reasonable effort to ensure that the lawyer complies with the rules of professional conduct in the State Bar Act. They also may be responsible for another lawyer's violation of the rules or State Bar Act if they order conduct that would be in violation, or with knowledge of relevant facts and specific conduct, they ratify that conduct, or they know of the conduct within time to avoid the adverse consequences to the client. So in answer to your question, no, actually, the rules don't require this kind of level of supervision necessarily. And I agree with you that in most situations, any attorney worth their salt obviously is going to check. But what we're always concerned with these rules are the attorneys that don't follow those kind of best practices necessarily. And as I think Neil pointed out, I tend to gravitate towards the solo practitioners who just may, from the press of business or whatever, may gloss over certain pleadings or contracts that are signed in the name of a client or provided to a client or an opposing party, and they haven't given it a good review beforehand. So there may be some concern with that as well.
Got it. Okay, thanks. So Jennifer and then Rupa has a hand up, and then Tiffany. And welcome, Judge Herman.
Thank you, everyone.
Yeah, like so many of these things we've talked about, the papers vary so much, right? Some things can be extremely routine, almost a template that it doesn't seem like it would need to be reviewed necessarily. I mean, I know if I were supervising one of these folks, almost every single thing that went through, if it were my bar license on the line, I would feel like I would need to review it personally or to delegate that to another senior attorney to review. But there conceivably could be a wide variety of things that are so routine that you wouldn't want to mandate necessarily and have it become overly burdensome for the hiring firm or agency. And so, you know, I can see arguments on both sides of this for sure, but I think I'm inclined to not include this requirement and then again, just leave it to the discretion of the supervising attorney who really does have, you know, potential disciplinary proceedings hanging on the line for not doing a good job supervising these folks.
Yeah, and we do have the rule that they're professionally responsible for it. Okay, Rupa, and then Tiffany.
Yeah, I agree. I think that just having talked to so many employers in so many varieties of settings, it's really hard, and it's hard to specify this here. My suggestion would be, you know, leave it to the discretion of the supervising attorney, but if we need something and if we are having supervising attorneys do a declaration, then something in the declaration about reviewing, you know, or signing off might be okay, that they're certifying that they'll do that in their declaration, but not in these rules. That's going to determine whether a supervising attorney even wants to take a PLO.
Okay, Tiffany, and then Diane.
I agree. I can't see how it will work in our office, for example. I'll be the one charged with sort of selling this program to the managers in the office. And if it will require additional resources from our office, I mean, we already have a robust training program with multiple layers of supervision and training and mentors. But if it were require the supervising attorney, that designated person, to sign every single I mean, that's a lot. You think about per public defender, how many cases they carry at a time. In misdemeanors, for example, that's a lot of, is that plea bargains? Do we sign off on tall waivers? Are we signing off one? It would just cause so much more work for the supervising attorney that I don't think it'll be worth it to us to have the program. In addition, the supervising attorney's name is on the document. That was already agreed upon. So their name is there. Why do they need their signature as well? I think people will take it more seriously being a supervisor if their name's on the document that's filed in court.
Okay, Diane.
I actually, when Rupa was talking about certification, I'm confused by this document that they're going to sign and certify and putting in it things that aren't actually required by the rule. So at some point, are we going to see that document, Donna, or?
So Diane, I was going to comment on that actually. Generally what these forms are, they are lifted straight from the rules. If you've got a requirement that the supervisor is going to do X, then we're going to require the supervisor to attest that they're going to do X. I would be highly uncomfortable putting something on this form that is not actually a requirement in the rule, because how can we ask them to attest to that?
And that was where I was headed with that, because I would agree with you on that point.
Yeah, so then I think just leave it out, leave it to the supervisor discretion. I haven't met a supervisor who hasn't been very diligent in this kind of stuff, and I do understand solos might be in a different situation, but I still think that with their license on the line, or them being the fish on the hook, most are going to be very responsible about this.
You changed my mind.
All right. And then what about the final disposition question? So New York does require the approval of the supervising attorney for final disposition of a matter. Rather than overcomplicate things, I would submit that this also falls into the, the supervising attorney is professionally responsible. They would be approving any final disposition in any event.
I agree with you, Halen.
Okay.
Does that mean that for my purposes, does that mean every plea would have to be approved by a supervising attorney?
It seems like that's what that would mean. So my proposal would be to not spell that requirement out. It's just to trust supervising attorneys to exercise appropriate levels of supervision.
So moved.
So seconded.
All right. Ezra, could you call a vote, please?
Hyland Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Chris,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Judge Herman. Oh, Judge Herman, if you want to unmute. Is he? Okay. Paul Kramer,
Yes.
Carol Langford,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Abstain.
Philip Talbert,
Yes.
Tiffany Townend Blacknell,
Yes.
And then Judge Herman is now unmuted.
I abstain.
Okay.
Great. Thank you all. So that motion carries. It is now 12:20, and I would propose we take a 15-minute break, but then continue to eat lunch and work at the same time, the way we did last time, so that we can move this along more quickly. Any objections to that? So we would be coming back at 12:35. Next up are some more miscellaneous issues, and then we will turn back to an issue that we left on the table last time, which is the issue of fees, as well as looking at the rules that have already been drafted.
Okay, so 12:45, right?
I said 12:35. Do folks
Oh,
need
okay,
to-
I was 12:35.
Okay, got to keep you guys moving. Okay, 12:35. See you guys back. 12:35. Thank you guys for being so timely.
And
and coming back.
I would like to just apologize to everyone. I'm in trial, which is why I could not make it until the noon hour. So only the second jury trial that we've had in the county since the pandemic. So social
Wow.
masked and socially distanced. So
Goodness.
very-
Well, thank you, Judge Herman, for joining us.
you bet.
Just to orient folks who are joining us right now, we are on page 16 of the memo that was used during our first meeting. We are now on to what is categorized as other miscellaneous issues. So looking at page 16, the first main bullet point under other miscellaneous issues is when provisional licensure terminates. And before us is a proposal. The provisions are largely consistent with the provisions of the multi-jurisdictional practice rules and several other states' rules. And they generally provide for termination of provisional licensure upon imposition of discipline and for various other reasons. Those include admission to the state bar, cessation of the provisional licensure program upon request. I assume that's upon request of the provisional licensee. Failure to comply with MCLE and related fee requirements. And if the provisionally licensed attorney no longer meets the requirements of this rule. And Donna, would that apply if, for example, there is no supervising attorney for this?
Yes.
The provisional licensee? Okay.
Yes.
Questions, discussion?
Paul,
Paul?
as translated in the proposed rule, Um, I think this is a point I raised the last time. It just says upon issuance of an adverse moral character determination, which obviously isn't going to be an issue for MJP or others because they will have had a positive, but we're allowing people to enter the program while their determination is under review. I was concerned about the ability to postpone the effect of an adverse staff determination by appealing it. And I don't know if we agreed the last time, but I thought we were leaning towards saying that if staff determines, at the staff level, that you're going to get a negative moral character determination, then they would be suspended from this program until they received a positive result on appeal if they were able to do so. And then my second question is with regard to the fees. It only talks about the fee related to MCLE, but should we also mention the annual fee if there's going to be one, for instance, other bar fees?
So I think we were assuming that this was a one-time fee because the program was going to be shorter than 2 full years. And so potentially shorter than 2 full years. So I think we were talking about it as a one-time fee, and that's the only reason that I didn't put that in there, Paul, because they wouldn't become a PLL if they didn't sort of pay the fee, unless we are talking about a payment plan or something like that, and then certainly we could. And when we get to the fees, Amy's gonna go through some of that. So that might be something as well. So we can use that as certainly put a placeholder there if there are other fees.
Are there possibly going to be other fees we're just not thinking about that would normally apply to them?
I guess because we're not thinking about them, the answer is sure. I guess there could be.
Well, there's going to be moral character fees, right? That's like 500 something, right?
Well, they would have already had to have applied for moral character.
Right.
Okay. I just think a more general statement would be a catch-all. And especially if other fees somehow come upon them. And if the program were extended, for instance, at some point, you have to say that the beginning, the upfront fee no longer covers the full cost of administering the program. But my more important point is that I don't think they should be able to, it's one thing to presume and let them into the program while their moral character determination is pending, but I don't think they should be able to postpone their exit by engaging the appeals process, for instance, if they get a initial negative result.
Okay. Diane, you had a hand raised?
So I was a little confused. There is a catch-all provision on fees, isn't there? Are you arguing against that, Paul, or? Because it says they're to pay any related fee set by the bar.
Well, related, I would read that to be referring to the MCLE requirements.
And actually, that's an error to include that in there because now we have determined that the only MCLE requirement we are imposing is the 10-hour new attorney MCLE, which has no fee. So that would be corrected anyway.
It sounds like we need to correct it and make sure we're referring to sort of all fees. And for this one, it looks like there is a draft rule that State Bar staff has drafted. So if folks are looking at the rules document, it appears on page 4 of the PDF under subsection J. So we're looking at J1 if folks want to look at that document.
Yeah, and my concern is about subsection 1C. When is an adverse moral character determination issued? Is it only after the appeals are exhausted? Or because the way it works now with the Committee of Bar Examiners is only negative determinations from the staff are even appealed to us. And if staff goes ahead and approves somebody, then we never see that. So I just don't want somebody buying extra time by filing appeals, because those will take a while.
What about the idea of suspending the provisional licensure status upon a staff finding, and then full termination? So if they appeal, that's fine, they have those appeal rights, but they aren't practicing as a provisionally licensed lawyer in the meantime.
Yeah, that was what I was looking for.
I agree with you, Paul, because if they're getting an adverse one, from what I've seen of moral character and the people and the decisions they make, they're good decisions for the most part. And I think that they really give people a chance. Even some of my clients who I don't know if I'd give them a chance if they, but they're my clients, I'm arguing for them. So I like the idea of them not dragging it out with appeals. And not being able to postpone it, getting temporarily suspended, because you can do an appeal. There's 2 appeals, right? They get it first to staff, then they go to a hearing, which can take 2 years, right? Or by the time they get in there and then they have the hearing, well, it can be at least a year. So I would agree with you on that. And I like the idea of a suspension while it's pending.
Okay, there's a bunch of hands up, but I think they might all be legacies, unless Greg or Neil, you have a new hand up. No. Tiffany, you have a hand up too.
Yeah, I guess I don't know what types of things trigger the moral character action. And I would hate for people to lose their job essentially before a final decision's made. It seems to be, because it's not their fault that the process takes so long, right? I guess we are concerned, there are those who are concerned about them using it as a tool to delay the process and to continue to work. But, you know, I've had a couple of law clerks who've run into trouble and have not been allowed, even past the bar, and have not been allowed to practice in our office because of the moral character hang-up. And now they're all members of the bar. It was just a delay, but it stopped their life for a year or two. And one, because he wasn't able to join our office, he missed the opportunity, and now it's closed. So I would hate for the fact that it takes so long to actually work against them, to be used as a reason why they shouldn't be able to trigger it.
It doesn't, because unlike somebody who passes the bar and cannot practice until they get a positive determination, we're letting people just file their application and let the process work out. And so if somebody had moral character issues, a longer process would actually benefit them, because they would get the thumbs down ruling later than they might otherwise.
I see your point, but we have to look at this in terms of, in the context of a pandemic. These students are already disoriented and dealing with issues that are out of their control. And so many of them will be hired as these PLLs, which most of us would agree that are not going to be compensated as full attorneys. So they're already suffering that because of this uncontrollable issue with the pandemic. And then they'll have to cease employment immediately upon a triggering from the bar, which may or may not take years to resolve. And so they're neither members of the bar nor are they PLLs for however long. I mean, I think it would result in a delay of their lives, unfortunately. But also from an employer's perspective, am I going to invest months of training into someone who at a moment's notice could be just removed from my office? I mean, I don't know if that's worth the investment. If it could be that they will have to cease employment, just my thoughts.
So I think, Tiffany, to give you a sense of confidence in the process, we get something on the order of 6,000 moral character applications every year. 180 or so of them go to informal conference, which means they are sort of they are on the verge of being, they could potentially be denied. If you're going to be denied, you have the right to go to an informal conference. So we're talking about 180 of those 6,000, which could potentially be denied, and then some percentage of those 180 end up getting approved. So what we're talking about is that number less than 180 that are getting denied, and I think that suggests that there isn't sort of a character and fitness process run amok at the state bar, that this is very carefully considered. And I don't think that, I agree with what Paul is saying. If you've got sort of that staff level determination, which really is for a very small number of cases, that moral character application is being denied, then I think that is something that warrants suspension of the provisional license until there's a final determination. Tara has turned off her mute, which tells me that she's going to correct my numbers a little bit.
No, I just wanted to add on and just reassure folks a little bit. So although if someone is denied by staff and then the denial is upheld by the committee, if they go to state bar court, that may take years. But the interim step, the appellate step with the committee of bar examiners, once we receive that, they have to review that within 60 days and then it's decided at the next meeting. So if it gets to that level, then it's not drawn out for that long. So there are a couple of steps along the way. And then just in the context, since we've been discussing MJP folks as well, for those folks, the way the system is built right now, if they receive a negative determination, their MJP participation is automatically canceled. So it seems like the suspension is kind of in between the two, of either letting them continue on or just completely canceling them. So that's all I wanted to add. Thank you.
And just so we're clear, in terms of our office and me being placed as a recruiter this year, and it's informed by my activism with criminal justice reform, I'm almost seeking out people who are system impacted. And those are the people who get flagged, the people who have had juvenile convictions, the people who've had prior felony convictions, people who've had, system involvement. And so those are the people who we want to bring to this work because they inform us to be better advocates for folks who are in custody. And so if those are the ones that seem to be the problem, the holdup is my point. And maybe, large firms don't really court that sort of talent. We do. And so I think we're probably doubly impacted by the rules that require such a delay in their processing. But I didn't realize I'm in a minority in that.
Well, you know what, Tiffany, not really, because I've done hundreds and hundreds. That's what I teach, and I get hundreds of moral character. Tara, you all know me in moral character, and I have to say, it's true, very few go to hearing, and the ones that do go to hearing, I would agree every time they should have their hearing. And when they go, very few. I mean, the moral character, I think in California, they give everyone a chance, and very few actually get denied. And usually it's not because of a felony in the far past. People can have felonies. They can have DUIs. They can have all kinds of stuff. But it's many things, like how recent is it? Is it 2 years ago? Did they cheat on the bar? They've seen all kinds of things. So those are the real factors, not even what they did. So my sense of it is, if anything, the bar errs on the side of letting them in, because they're checked. There's checks and balances. There's a hearing that could make them look bad if they lose, that kind of thing. But I would say that very few, if we looked at it from statistics of the applicants are denied, is very few. And the ones that are the serious, in time, serious with real questionable conduct, and they get in front of the committee and they justify bad conduct. I mean, not, hey, I grew up in a bad neighborhood and that's how it happened back then. I've changed. That's way different. But there are people who actually get on drunk to hearings. I've seen it. Clients who 3 and 4 DUIs say they're not an alcoholic with high blood levels. Those are the kind of people that are getting denied. So I think people get a fair chance. I really think you can be comfortable with that. And I would tell you all if I didn't feel that way. And I've seen hundreds. I handle hundreds of them.
So we have a bunch of hands raised.
Sorry, can I just add one more point related to some of the information we're sharing in terms of where we're at also with moral character application processing? I think I mentioned this before, but I just want to remind everybody that of those people that are already registered with us in some form or another, that is people who have registered for a bar exam, have registered as a law student, or their moral character application, who we have some indication that are part of this 2020 graduating class in our database. 35% have an application in process, 26% have an approved moral character application, and that leaves a remaining 38% where there's nothing that has been started. So it's a smaller part of that well, it's about 35% of the pie, or 38% of the pie. And the thing is that, and I think we mentioned this before, we really try to encourage everybody to start this while they're still in law school. And this program, it sounds like it's a gap fill for, it's designed to address that gap of people who are ready to take these positions on. And so, I just want to highlight that I think for the majority, a lot of these applicants would be ready or have some kind of outcome.
Okay, we have a number of hands up. Let's go with Greg and then Jennifer and then Rob.
Yeah, I was just going to build out a little bit on what Carol said, that obviously prior convictions for misdemeanors, felonies are not disqualifying per se for the practice of law. And that includes people who have been disbarred. I handle a lot of rehabilitation petitions. Really, the touch mark, the keystone is really whether or not they're fit to practice in the estimation of first the committee of bar examiners and ultimately the court. But the only thing that I would say is that to allow a PLL to continue to practice when they've received an adverse determination would seem a bit incongruous to me when a lawyer could not practice, could not even enter the practice of law without a positive determination. So you would have a situation where a PLL could continue to practice, but an attorney, but they couldn't do so if they were, a fully licensed attorney. And I understand the circumstances that we're dealing with the pandemic, but that incongruity will be hard to, I think, wrap our heads around.
Okay. Jennifer, did you have a hand up? Okay. Rob?
Well, I'm joining Tiffany in the minority on this, and I disagree with Carol, and I disagree with Paul, and I do work with the state bar too, and I'm probably shooting myself in the foot, but I don't have as much faith in the system. And the problem is not the bar's problem. There's not enough staff. These delays go on forever. If you're going to deny one of these provisionally licensed folks because there's a proceeding against them that hasn't been resolved, that's the end of their career as far as being a provisionally licensed lawyer. It's just a death knell. That's it. It's over for them.
So I just want to remind folks that the last time we met, we had a long debate over whether to allow folks to be provisionally licensed without a final determination. And we decided that because we wanted folks to be able to practice, we wanted them to start being provisionally licensed so long as they had a moral character determination pending. All they had to do was have one pending. And then later, if it was determined that they, didn't satisfy the requirements, then we would take action. And so to me, I think that Paul's proposal is a good balancing of those two things we were trying to achieve. One, getting folks into the system, getting them employed, letting them starting to work before the moral character determination is complete, but then taking action in a way that is, as Greg noted, consistent with how we treat regularly licensed lawyers, which if they have this determination, then their license is suspended, while their appeal works out. So I think we need to be mindful of the fact that we were trying to balance a bunch of things when we decided first to allow them to have the license before moral character was done.
I guess my question is, what do you mean by complete? after the end of the appeals process?
We decided last time that folks could have a provisional license, just they needed to have started the process, just have an application in. Judge Herman?
No, I just say, I think, you know, again, given the numbers that we've been told about in terms of 180, et cetera, that really public safety, we can't set aside public safety. And if something pops up on someone, I think it's important to look at that and to look at public safety as being the balance. So I agree with Mr. Kramer's and others' position, Greg Fortescue's positions on this issue, and Carol Langsford.
Dolores?
Yes, I'd like to echo what was just said. From a public member point of view on the Committee of Bar Examiners, I think one of the best things that the bar does and that the Committee of Bar Examiners does is the moral character review. That is from, I've sat on the committee for on and off for 4 years. I can attest to the fact that what Carol said is true. We really try to take the individual as an individual and make determinations based on their individual view of life, where they are now compared to where they were when they committed some transgressions. So it's a very, very fair process, and it's a it gives me as an individual peace of mind knowing that we are doing that. The other thing is that for those individuals who might be concerned that there's a disproportionate number of minorities that go through the moral character process and end up in the committee for a review, is not disproportionate number. Is from what I've seen. That's what I have personally seen. I've never seen statistics, but I don't believe that for those people who might be concerned about that is an area of concern.
I would say that from my experience of all my clients, I would say that's true. It's all different people, men, women, all races, it's everybody. You don't, for example, I don't only get, you know, minority clients that get held up. I would say, in fact, I think it might be white males, young white males, that I see a lot of because of fraternity shenanigans and stuff they did later, cheating, you know, all kinds of stuff. So I would say it's mixed, all ages, everything.
Is there data actually that's produced surrounding moral character? Do we know? I realize there has been some issues with Black males being treated differently or disproportionately facing discipline. I would be surprised if that were restricted to discipline. I understand that we do have a difficulty with bar passage, obviously, with passing the exam. That's obviously there. But I would be interested in knowing what are the numbers for moral character.
So I recall, Kara and Amy, that about a year ago, we pulled some information together on, 10 years of moral character cases in terms of the reason for denial. Were there other statistics, other demographic statistics that were involved in that data that we had pulled together?
I can just speak from what I saw, that at my level that I can't see that demographic information in Ames. So I don't know if Araya added that in afterwards, but that was not collected by my staff.
I think that's the issue, is that we don't, for when we process applications, whether it's a moral character, bar exam application, we don't combine race data or demographic data with those applications.
See, in my cases too, this is interesting. I think I have a much more compelling case if I have a minority client, particularly one who grew up poor, because that is a better sell, you know, than somebody who's white and had a money and it comes from a good family and they messed up. I think I always feel like they're the you know, the minority candidate is going to do better in front of moral character. That's just my observation from my cases. So it's kind of interesting how it plays out, sometimes differently than people would think, you know.
You know, when I mentioned system impacted, like that class of student that we seek out, I wasn't referring to race. I was referring to people who are impacted by the justice system. I know that's disproportionately Black and brown folks, but I wasn't narrowing my focus to race. That wasn't what I was implying. But now that it's been brought up, it begs an interesting question, because although I certainly believe that you do have that analysis, Carol, in your processing, but implicit bias affects us all. And so it's not something that's consciously being done necessarily, but it would be interesting to know how it plays itself out in terms of the numbers. I mean, because if you don't collect data, you don't know the results. But
Neil, you have a hand
I'm
raised.
searching for that analysis that we did, Tiffany. I will speak up if I'm to find that while we're talking.
Sorry, Taylor, just a quick thing about discipline rates and disparities with African Americans and other races. Apparently, the disparity shows up once you see more than 10 complaints filed for an individual attorney. And it's that subset that shows a disparity. And of course, folks at the bar can correct me if I'm wrong. But yeah, moral character is something that I don't know. I've never seen the data for.
Jennifer?
I'm struggling a little bit with what to do here, but I go back to a comment that was made earlier. You know, what we're trying to do here is a really limited term fix for, you know, attorneys who are, or would-be attorneys who are stuck not being able to take the bar exam because of the COVID crisis. I mean, it does sound like there are bigger issues with the moral character evaluation and, you know, perhaps the injustices that are in the system that warrant deeper review, but I'm not sure that trying to, you know, deal with this very time-limited, narrow issue that we're confronting requires us to go there necessarily. So I keep going back to, you know, just trying to make it as comparative as possible to the situation these folks would be in if they had been able to sit for the July bar exam. And the comment that was made earlier that if they had been able to sit for the July bar exam, but their moral determination or character determination had not resulted in a positive result, they would not be licensed. And so if we're trying to do what we can to make this as equivalent as possible in the short term until we can get back to a normal bar exam schedule, or until there's a deeper dive into some of these issues about the bar exam and about moral character determination, it does seem that, you know, we already allow them to pursue this application while it's pending because of the timing, et cetera. But if they get a negative determination, it does seem like that would be the place where you would pull back on this provisional licensing just to try to make it as equivalent as we can to what would have occurred if they had sat for the July exam. But, you know, I'm struggling with it. I think there are some issues there, but that's what would have happened with any folks that get caught up in this determination. If they had sat for the July exam, they would not be licensed until that moral character determination were resolved. So.
I don't disagree with you, Jennifer, but I do disagree with the notion that this might not be a conversation surrounding race and equity, because the pandemic itself has affected Black and brown folks more disproportionately than other groups. You have Black and brown folks have multi-generational households, which have older people who are more susceptible. They are the essential workers, right? And so, you know, they'll have children around. I saw in the summer with my summer clerks, you know, I saw grandmother in the back in the kitchen cooking, and I saw a little boy run into the screen during our Zoom meetings. These things will affect them at the bar as well. And so because of the disproportionate effect of COVID, of the racial unrest, of that crisis, it affects these class of students far more. And because of that, they'll probably be less likely to sit for the bar in October with multi-generational families and not having the space to study and not having the quiet, not having access to Wi-Fi that's reliable, right? This will affect them more. And so I think we should, in all of these considerations, look through the lens of equity and race. I think it's important.
Neil?
I think there were some other folks that had their hands up before me, but I was just going to quickly say that, you know, under our day one discussion, right, we're already letting these folks in and practice without having to have a positive moral character determination come back out. And I think that's the balance here, right? And that's the leeway that we're affording this group that is really trying to enter practice the law under really extraordinary, difficult, painful circumstances. So, but at the same time, we have to balance out the public safety. So if it does come back as being adverse, just like an attorney that would have had the same thing happen if they had sat for the bar and passed, they wouldn't be allowed to practice.
Then Rob, I can't tell if your hand is up from before.
It's down.
So what are we now getting ready to vote on? We kind of moved around a little.
Yeah, so I'm sorry, go ahead, Helen.
Go ahead, Donna. I mean, I think we should tackle this issue that Paul raised first regarding the moral character determination, and then we can talk about the other items.
Okay, whether moral character, if they're denied, they can still be a provisional licensed lawyer as they go through the appeal process. Okay. And I think everyone knows my position would be no. Because of how rare it is that people are denied. So small a percentage.
Diane?
Didn't you suggest, Halen, that we do something like in between, and maybe this doesn't make sense because of the time period it takes between the issuance and the appeal, but you suspend them and not take away the license, and then if the outcome of the appeal is that the issuance is overturned, then they go back to the provisional license, and the obvious conclusion, if it's upheld, is then they're terminated?
Yeah, I think that was Paul's suggestion. It wasn't mine, but that seems to be the proposal that would line up with, you know, how regularly licensed attorneys are handled in that process.
Well, I'm willing to move that if we need to move these individually. I don't know if we need to, or we're going to take them all in just one fell swoop.
I'd second it.
Okay, so motion from Diane and second from Carol. The other items here seem to be fairly non-controversial, so I think we should take this one separately, and perhaps the other ones we could take all as a block. Any discussion?
Can you please restate the motion?
So the motion would be, and I'm going to say this generally and let the people who are good at drafting rules work this out. The idea is that upon the issuance of assuming the issuance is the first step of the adverse moral character determination, the provisional license would be suspended, and then it's suspended until there's a final disposition of an appeal. And I suppose you'd have to figure out if they don't appeal it, then it's a termination. but that's the idea. And then once it gets through the appeal, if the issuance is overturned, the license is reinstated. If it's not overturned, then it's terminated.
And to be clear, the issuance is by staff because they make the first determination that's subject to appeal to the bar
Right.
examiners.
I assumed it was somebody at a level that then goes up to a higher.
Yeah, so we'll just draft that with a reference to the rule that talks about the staff level determination.
Any further discussion? Ready for a vote?
I have something.
Oh, Selena has a comment.
So really quickly, with regards to the MJP applicants, as Tara mentioned, as soon as they receive an adverse moral character determination, they are no longer allowed to participate in the program under the rules for MJP. So I just wanted to add that.
So they're terminated from the program effectively?
They're suspended, but under suspension, they are not allowed to practice under the rule.
And that was the intent of my suspension as well.
Okay.
Call the vote.
Okay, seems like we're ready for a vote. Ezra?
Did we get a second?
Carol did.
Carol was the second.
Hyland Chin,
Yes.
Ruben Duran,
Yes.
Ruben Duran,
Yes.
oh, sorry. Rod Barrett,
No.
Rupa Bandari,
So just to be clear, we're voting on Diane's proposal for the language?
correct.
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Judge Herman.
Yes, and I have to go back to my trial.
Okay, thank you.
Okay, thank you.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Philip Talbert,
Yes.
Tiffany Tonnen Blacknell.
No.
Thank you.
All right, thank you. So the other items under termination are the following, and you can follow along either on page 16 of the memo or on page 4 of the draft rules, looking again at subsection J. So it's imposition of any sanction for misconduct by the state bar or other professional licensing authority. Imposition of any sanction for misconduct against the supervising attorney. Maybe we put a pin in that. The other ones are upon admission to the state bar, cessation of the provisional licensure program upon request of the licensee, failure to pay fees or meet the new attorney CLE requirement, and if the provisionally licensed lawyer no longer meets these requirements. So Anna, it seems to me that the imposition of a sanction against the supervising attorney, couldn't the provisionally licensed lawyer just switch supervisors, or at least seek to do that before they're terminated?
So long as they do it within the same employer, right? That would be consistent with the discussion that we had at the first meeting. If they switch supervisors within the same employer, they're fine. And they just need to submit that sort of updated declaration. But if they have to move employers, then they would have to reapply. So we can make that clarification.
Okay, discussion. Tiffany, is that a hand raise? And then Neil? Oh, okay. Neil?
Yeah, I'm just for point of clarification, what does imposition mean? Does it mean if it's been ordered by the state bar court, or is it after the hearing department? Is it after the review department looks at it, or is it after it goes up to the Supreme Court? It's an open question.
Certainly one approach would be to follow the same thing that we just did with moral character, upon the initial determination of the State Bar Court, then it's suspended and it's only terminated upon final disposition.
And is that consistent with how MJP handles it?
For MJP, it's the result of the discipline. So once it has been, the result has been determined, that's provided to us, and we will terminate the application.
But determined by whom, Selena?
State Bar Court.
I'm ready to move that we approve all those.
I would second that.
And that's subject to the clarification of about the supervising attorney within the same entity.
Yes.
And also, were we adding the same kind of suspension language that we did with the moral character? Yes.
Sure.
Okay.
Other friendly amendments or discussion?
Can you please restate the motion?
It's to approve all of the provisions in the first bullet on page 16 or Rule J1 on page 4 of the rules draft, except for the previously discussed moral character issue. But adding the clarifications we just heard that if there was a discipline imposed by the State Bar Court, they wouldn't be terminated, they would be suspended until either the program expires or a higher court reverses what the State Bar Court decided.
And then the other clarification is that if the supervising attorney is subject to discipline, it doesn't automatically terminate you if you find another supervising attorney within the same entity.
Right, and I think it would be really helpful to make that clear so that people aren't thinking that they're doomed and miss their time to take the way out.
Thanks.
Any further discussion?
Neil, is your hand, is that a legacy hand?
The old hand. Okay, Ezra, could you call a vote, please?
Kaylin Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Carrie Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Judge Rodriguez, Judge Rodriguez,
I think he had to drop off.
okay. Angela Sierra,
Yes.
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great. Okay, we are on to looking back at the memo now. On page 16, the second to last bullet point. Fairly non-controversial. It's just that the same privileges and confidentialities that apply to licensed attorneys also apply to provisionally licensed attorneys. So I would want the drafters to make sure that we make sure it's drafted to include attorney-client privilege and attorney work product. Any discussion, objections, concerns?
Move it.
Greg?
Just for the purposes of your motion, if you're moving towards that, I would probably substitute the word duties instead of privileges.
That's smart. Yep.
Or add
well,
duties, I would say, I guess.
I'll take that as a friendly amendment to the motion.
Wait, I'm confused. We're saying that same duties and confidentialities apply?
And confidentialities would be redundant because you have the duty of confidentiality. So unless you really want to emphasize that particular duty.
So when you're talking about duties, you're talking about duties in the context of the duty of confidentiality and then cloaking things with attorney-client privilege or work product. You're not the whole realm of duties that might be in the B&P code for a lawyer, right? You're just talking about those areas?
And the rules of professional conduct, yeah.
Okay.
That was the way I was reading it. Duties of loyalty, avoiding conflicts of interest, that kind of thing.
I just read this as a more limited provision, but I don't care either way. I just want to make sure we're clear on what we're voting on.
Yeah.
Well, but don't we already have, we already decided that the provisionally licensed lawyer is subject to the rules of professional conduct and must submit to the state bar's disciplinary authority. So this would be separate.
Yeah, I was reading this, I think similarly to Diane, as a more limited provision designed to clarify that work product and attorney-client privileges covered the communications with the provisionally licensed lawyer.
Nice.
I guess I'm not seeing how that's different. I'm sorry.
I think duties is broader, right? Because you've got like a duty of loyalty and a duty of all, you know, name all the duties that the state bar rules impose.
Right, and when we talk about confidentiality, are we talking about the duty of confidentiality or the evidentiary privilege for attorney-client communications?
As drafted, we were talking about the privilege. Talking about attorney-client privilege, we were talking about attorney work product. That was the intent here, because as Helen mentioned sort of earlier in the draft, we do talk about the fact that they are subject to the rules of professional conduct, and so those duties of loyalty are already things that they are subjected to.
Right.
People get real confused by confidentiality and privilege, and sometimes judges do, sometimes case law is a little confused on it. So if you say duties, you don't need to say confidentiality.
Right, but I think what
we have a rule, right? 1.6.
But this is clarifying that the evidentiary, just so that there's no doubt, right? Some people may say like, well, are my communications with a PLL privileged, or is the work product created by a PLL subject to the attorney work product doctrine? Could I withhold it from disclosure in discovery if it's drafted by a PLL versus a regularly licensed attorney?
Are they privileged and or confidential? Because something, you know, privilege is under confidentiality. Confidentiality is broader.
Yes, much broader.
What if and just to be clear, like the duty of confidentiality under the rules of professional conduct directly cite and incorporate 6068E1, which is the broad duty of confidentiality that covers all secrets between an attorney and a client. And privilege, as Carol's alluding to, is an evidentiary privilege, which, I mean, there may be times in which privilege does not attach. It doesn't allow it covers what happens in the courtroom and what gets admitted into evidence and what doesn't, and what are the exceptions. But the duty of confidentiality is much broader for an attorney. So even if something is admitted over a privilege objection in court, that does not free an attorney necessarily from disclosing that outside of the courtroom. So if what we're saying here is that the privilege, attorney-client privilege, should apply to PLLs, I'm just wondering if this is whether it's going to require a statutory change in some way to.
Well, so one other way to get around it, Greg, is that we could do the same way the Washington legal intern program does it, which is to basically say that a PLL is under the supervision of an attorney. And so the same attorney work product protection that applies and the same attorney-client privilege that would inhere when you're supervising someone would just apply here. I do see some benefit in spelling it out explicitly so that employers aren't like, oh my God, if I put a PLL on this, does it mean that somehow it's not privileged or somehow it's not work product?
Yeah, and I think that nothing preventing from the group from voting on it as a motion and then turning it over to rule makers and everyone else who has to figure out exactly how this is going to fit into the statutory framework, as well as if any rule changes are needed. May not be, I don't know.
What if it just said the same evidentiary privileges that would apply to licensed attorneys also apply to PLLs?
Well, the work product doctrine is in the Code of Civil Procedure and not the evidence code?
It's common law, I think.
Well, there's also a provision in the evidence code, I believe.
Anyway, whatever legal scheme applies to those doctrines. I mean, just from a policy perspective, perhaps as Greg suggests, this group should just vote on the concept that these privileges and work product doctrine should apply to PLLs the same way they apply to regularly licensed lawyers.
Yes.
I agree. I want to stay away from duties as a broader term.
Yep. Okay, do we have a motion?
I'll move that.
I'll second it.
Great. Motion by Terry, second by Diane. Ezra, could you call a vote, please?
Eileen Chen,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Christ,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Judge Rodriguez. Oh, okay. Angela Sierra,
Yes.
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great. Okay, last item on page 16, which is the state bar shall have the right to audit the provisionally licensed attorney and supervising attorney for compliance with program requirements. Other states don't appear to have such an express requirement. Do we need it if the PLL is already subject to state bar rules and discipline and the supervising attorney is as well?
Fair question. Looks like Selena may have a thought on this.
Currently, our MJP attorneys, like regular admitted attorneys, they are audited randomly for for MCLE compliance. In addition to that, they also are required to file an annual renewal, at which time they submit a declaration confirming that they still meet the requirements of the program in order to participate.
We're talking a lot broader than MCLE. We're talking about sort of all of the program requirements.
Okay, at that time, that's what's handled during the annual renewal for MJP attorneys.
And Selena, does that audit take place, like, is the fact of that audit spelled out specifically in the MJP rules, or is that just something the state bar does?
It's not very detailed, but it is in there where it does notify the applicant that they will be required to submit an annual renewal, which includes fingerprints, state bar licensee fees, MCLE, and all of the requirements that they have the ability to update any changes with regards to their employer, address, or things of that sort.
And I guess I'm confused by audit because there's many ways to do it. You can send a letter and say, have you complied with MCLE? And they turn it in yes or no, and the bar can check. You can audit trust accounts by subpoenaing records. I've been appointed as a special master for raids of offices where you go in and everyone's surprised and you pull the files. And it can be a big endeavor and people can fight it. So I'm not certain why we would audit when you have the fish on the hook. Like, how many really is a bar going to spend that money and take that time to go in and say, are you really doing it? Is it going to focus only on solo practitioners and not the big firms? I'm not certain why we'd have a requirement of an audit.
I don't know that it would be required. I think the way that this is worded is just permissive, that they could be audited. And I could see, for example, I mean, I don't think that anybody should be going and tearing apart people's offices, but I do think that, for example, you might want to check to see people have done the new attorney CLA requirements, you know, or check to make sure they've paid their fees or something like that. And I think that the way this is worded is just permissive, but my question is whether we need it.
Now wait, they're gonna know, because the person has to register on the bar site or somewhere to take that new attorney program, so the bar can just pull up and see who did it if they want to know.
So in part, this is also about the fact that there isn't a renewal requirement. And since there isn't a renewal requirement, and I don't want to get people to get hung up on the word audit, right? There's a desk audit, there's a, you know, requiring you to submit certain information. And I think it's ensuring that there's providing the opportunity to ensure that there's continued compliance, being that you're not filing a subsequent renewal application where you are once again attesting that you continue to meet the requirements, et cetera, et cetera.
Then I think the language has to be worked on a little bit, because for people that do, you know, lawyer defense, people that do or what Terry does, people that do where they're really looking into this stuff, the word audit is going to cause a concern. Terry's shaking her head, and they're going to get all worried about it. So I think we have to reword it, because we really don't mean an audit. An audit is when you go in there and you are pulling the files and you are looking at everything, you're talking to people. To me, that's, you know, that's kind of like an audit. That's, you know, an audit. But an audit could be just a letter. Have you complied with your MCLE? So the word audit is a triggering word.
So Tiffany and then Angela.
Yeah, I don't see why we would need it. No other state has it. And it's only an 18-month or so program. It won't even be a full 2 years. So we don't need to have a renewal for that short term. If the program's extended because of COVID going in a different direction, then maybe you guys can reconsider it, but I don't think we need to have it right now. And I'm also concerned that the cost of the audit will be passed to the student, which is also increasing the burdensome nature of the program.
Angela?
I don't know if anybody has mentioned this yet, but do we know, is there already by statute or a rule that the state bar already has, I suspect it already has discretion to review or investigate. Maybe the word audit isn't used, but they likely have a certain amount of discretion on how they look into anything within their jurisdiction. And so maybe, you know, I somewhat like having a rule like this just to give people notice, you know, that this could happen, and maybe it's just a reference to that rule.
Angela, they don't have a word they can be just audited. We don't have, they're very careful about that. We don't have random audits of trust accounts. The bar's very careful. They do have random audits of MCLE, but we don't do random audits of going into an office and checking anything with supervision. So the only random audits right now I think we have, right? Or if someone complains to the bar, they can do an audit of the trust account. But without a complaint,
we have authority to do random audits of trust accounts. That's statutory.
Okay, so now, okay, they do, but it's rare, and I have not seen it. So it could, I'm sure it could happen. MCLE. But other than that, they don't go in offices, they don't check on supervision, they don't do that. Right, Donna? It's just.
Yeah, we do not, it is a very rare, it's only when we're really doing it like an assumption of practice that you physically see us out in the office But again, that's not what was being suggested here. This wasn't a raid. It wasn't opening all files. It wasn't, anything like that.
Right, is it more like making inquiry, or I don't know if there's like investigation is also kind of a, a loaded term, but that also can really run the gamut of something very simple, asking for information, or wanting to talk to somebody. So,
Terry.
Another thing that's troublesome to me about this is it combines the concept of an audit of both the supervising attorney and the PLL. Because I can understand that you might want to have the PLL confirm eligibility or confirm satisfaction of a particular requirement, like the modified CLE requirement we discussed. But if you're going to open up the supervising attorney to an audit and the parameters of that are not clear, that's going to be another reason why folks are going to want to pass on hiring these lawyers.
I think most lawyers would not want to think the state bar. I mean, I have nothing to hide, but would I really want the bar in my office looking through my files? I mean, I think most people wouldn't want that. And there's no need.
So I do want to sort of get us away from the word audit because it keeps leading to that discussion. And so let's assume we're talking about confirm continuing eligibility, and then sort of respond if that makes sense or not to have that rule in here, but that requirement in here, that's what the state bar could have. But sort of whichever direction you want to go in that's fine. I just want to drop that image of the state bar coming into somebody's office and rifling through files, because that's not what was intended.
Confirmed eligibility is fine. They send a letter just like with MCLE. If you met the requirements, they do it under penalty of perjury, like with MCLE, so they can be disciplined if they lie. And then you've got it covered and you don't have anyone worried about the word audit.
I like that. I also have a question. On the MJP program, does the checking, whatever word we're going to use, does that extend not only to the MJP attorney, but also the supervisor?
No, it is directly with the MJP attorney.
Okay. So again, that's what, the coupling of having both is troublesome to me because it's just a disincentive to work with provisionally licensed lawyers.
But now, Terry, all they're doing is signing a form saying, well, wait a minute. Okay, so they do this, what, a year later? Or why are they doing another I'm still eligible? Because I'm not exactly sure why they'd have to do that as I think about it. If they've already applied, they've done it, satisfied everything to be a provisionally licensed lawyer, then they're confirming eligibility. Why?
Well, there's some additional things that the PLL has to do, like there's an MCLE requirement in the 12-month.
Right.
Period. But
right.
I'm going to focus for a moment just on the supervising attorney and on what kind of additional exposure or burden we might be imposing on them. So what do they need to reconfirm and why? Especially when they don't have to do that in the MJP program.
I don't think it should be anything that's a requirement of the provisionally licensed lawyer, because they can't control that. Someone could not tell them the truth. It's the provisionally licensed lawyer's responsibility to take the MCLE and all that.
Right. So
maybe they could confirm in a letter, yeah, I'm doing my duty to supervise as I said I would, but that's about it.
Yeah, and then if that's under a penalty of perjury, they've opened up like a, yeah, I just don't know why the supervising attorney has to have additional requirements here that are not in the MJP program for this fairly temporary restricted time period.
So I would also note, Terry, that this document was drafted before a lot of the decisions that we made over the past 2 meetings about the role of the supervising attorney and the extent to which they have to sign every document or not, right? So there have been a lot of decisions that may make that not make any sense. Right, so this was drafted sort of before we had any of those discussions.
Right, right. That's really helpful. Yeah.
Dolores, you have a hand up.
Yes. One of the things that occurs to me with this bullet point is a question about whether there is a plan to evaluate this program at some point. And if so, the bar would have to accumulate information. And if that evaluation were for the purpose of making a decision at some point in the next year or 2 years to extend the program, all those issues in terms of evaluation might have something to do with the bar's right to audit, to collect data. I don't know. It's just a question.
So from the staff level, I don't think we thought about that, but I'm very intrigued, Dolores. Right, I think the issue is, do we think that there is a possibility that this could continue in the future regardless of COVID-19? If so, then certainly the court would want some data about the success of the program. And so, if there is the possibility that, in a future state, we would want to continue a provisional licensure program, then I think, Dolores, you raise a really good question. Should we plan to evaluate the program?
I think we have to assume this is going to last a while, and if it doesn't, it doesn't. I think we have to assume we may either never have a vaccine or it's going to be a long time before everybody gets vaccinated. I think the trend in regulation is less rather than more. And so I think we have to assume that it's going to last a longer time and just accept that and act like it is. And if it doesn't, we're prepared with statistics of how it's working and whether people like it, supervisors and the provisionally licensed, what works and what doesn't work. But we have to assume it's going to be longer.
Jennifer?
I guess my question is, this is just my ignorance, but does the bar have inherent authority to make these kinds of inquiries? Is there a need for us to address it in the rule? I mean, these are all important things in terms of being able to oversee the program and see how it's working and, potentially for long-term considerations. But is it something that we would need to grant to the bar in this rule, or isn't there some inherent authority to do that kind of oversight work?
So I think when it comes to the new programs, right, we have a sort of long understood sort of role and responsibility when it comes to regulating lawyers. But when we're adding these new programs, I think we want to sort of make sure that we've got some clarity here. And I also want to I don't want to minimize the deterrent effect that this is also could also bring, right? Just sort of making it clear that this is something that could happen, that the bar could reach out and seek to confirm continuing eligibility. It may not, but just sort of understanding that is a possibility. Again, this is a brand new program. This may make sense, it may not make sense, and so that's why we put it in here for folks' consideration.
Ruben?
It strikes me that when the court gave the bar this charge and then put together this group, it was a pretty limited task that we were given. And I feel like the conversation about whether it lasts longer or not is a little bit beyond the scope of what we've been tasked with. I don't disagree that it might make sense to evaluate the program at a certain point, But I feel like the conversation about evaluation and potential expansion of it, either temporarily or scope-wise, is beyond the scope of what the court has given us. That's just my gut, listening to the last 5 minutes.
Yeah, I agree with that, Ruben. It's really hard to predict what will happen come June 1st, 2021, right? Sorry, 2022. So.
I would say, I think it's important that we have something to point to in the rule that would require the supervising attorney's participation in providing us with information if we needed it about eligibility or their continuing supervision. Because the situation I'm envisioning is, what if we get a complaint about a provisionally licensed lawyer to us saying, I think this person's practicing without supervision, they submitted a declaration to you, but it doesn't appear that that person's being supervised anymore. If we don't have something to point to in the rule that requires the supervising attorney to confirm their continuing supervision, it's going to be really hard to confirm or deny that, this attorney is actually still meeting the eligibility criteria.
And along the same lines, even in our PTLS program, we've had a few instances, and I'm not saying it's a large volume at all. Like I could think of 1 or 2 from the top of my head, where we have had to go back to documents with that attorney because we've gotten complaints, and so there was practice that was happening unbeknownst to the supervising attorney. So we've had those scenarios. I'm not saying they happen often. Like I mentioned, there's 2 that come to mind. And so, yeah, I mean, something that would explicitly grant us that authority would be helpful for those instances.
But without the specific grant, do you not have it? And I would be worried that if you have a specific grant here, that would mean that people could argue in other spheres that you don't have it.
Well, say we wouldn't have anything specifically to point to, like, you're not cooperating with this provision in the rule.
Yeah, but we have a termination provision. It says that you can be terminated if you're no longer eligible.
Right, but how do you confirm or deny eligibility if there isn't an obligation to cooperate in an audit? That's what I'm thinking. Is like that gives us the ability to say your failure to cooperate, is enough for us to say you're no longer meeting eligibility. We could probably say that without explicitly putting that in the rule, but I think it would be helpful to have it.
Harry.
Yeah, how do you deal with issues about alleged lack of supervision now? I mean, there's rules on that now. So if there is a complaint that a lawyer is not supervising, a lawyer is a supervisory lawyer or a partner in a firm, and there's a complaint that they're failing to supervise those under their authority.
Yes. So the scenario that I've thought of is when we've received this complaint, the first thing we did is contact that supervising attorney to try to get more information, because it usually is coupled with like a reference. Like the one that comes to mind is a judge contacted us about a concern with a specific filing that a student was dealing with. We reached out to the supervising attorney and started that discussion there. I think what we would normally do under these circumstances is if we identified an issue, send that over to our Office of Discipline. Sorry, Selena, perhaps you could help me with how we refer those to OCTC.
In my experience, we haven't had to refer any to OCTC. I think that with Caroline's help, we have drafted letters and it stopped. I think we had a law office study student who tried to act as a PTLS student, and all we did was send a letter to the supervising attorney for the law office study student, and that ceased.
So we've had 2 types, and then some that have risen to the level of going to OCTC. Sorry, go ahead, Caroline.
Oh, no, it's fine. Thank you. I think that the renewal requirement also takes care of some of this in the MJP rules, because you've got the annual renewal and we don't have that here. So you're getting a renewed declaration that's updated. So if we have someone participating for 2 years and the first and only thing we ever hear from their supervising attorney is the declaration in the beginning, it's just going to be, it'll just, you know, be easier for us if we have the ability to confirm eligibility, and the supervisor is required to cooperate with us in our efforts to do that throughout that 2-year program.
Well, they're required anyway, right? If OCTC sends a letter, there's a duty to cooperate with an investigation. So as soon as that letter comes, all you have to do is say, all right, we got this complaint, it's from so-and-so, and it can be anonymous, by the way, too. And they're saying this and they're saying that, please respond. Lawyers must respond, or there's a separate charge of failure to cooperate that they could get disciplined for.
I think you're talking about disciplinary complaints, but we get like a host of other types of complaints about, you know, we could get other types of internal complaints about the attorney's participation in the program. So this would capture everything else.
So we spent a lot of time on this, and we still have a number of things to get through, like fees. And so I do wonder whether there's, I mean, I would prefer that we just leave it to the state bar's inherent discretion. We already have provisions that go to eligibility. We already have provisions that go to termination if you're not eligible. To me, that gives enough authority for the state bar to take action if they have information about somebody not being eligible, or even if they want to look around at it. I worry about putting an express provision in here when we don't have express provisions in other areas, which could then give rise to an argument that, well, the state bar doesn't have express authority in these other areas. So I would propose that we leave this one alone and not adopt an express audit requirement.
So moved.
I'll second that.
So moved by Carol, second from Diane. Discussion, or I think we should call a vote and move on. Ezra, could you call a vote, please?
Hyland Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Rupa Bandari,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Paul Kramer,
Yes.
Carol Langford,
Yes.
Judge Rodriguez, Angela Sierra,
Abstain.
Philip Talbert,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
All right, thanks everyone. Before we move into fees, why don't we take a short 10-minute break? And then just as a reminder, last time we sort of punted on the fees issue and asked the state bar staff to come back to us with a recommendation for some options. All right, so we will see you in 10 minutes at 2:05. Okay, folks, we'll just wait a minute for folks to rejoin. So next on our agenda is the appropriate amount of fees for participation in this program. When we discussed this last time, you'll recall that we talked about the fact that licensees will already have paid the fees required for the moral character application. The proposal on the table last time was that, you know, for the MJP programs, the fee is essentially equivalent to the annual licensing fee owed by California licensed attorneys. We talked about doing something less, recognizing that folks, especially during this pandemic time, may have less means. And I know the State Bar has worked on a proposal, or at least some options to discuss. And is that, I turn it over to Donna and Amy.
All right, so I am going to share my screen. In anticipation of this discussion, prepared a a set of relevant application fees that will help this conversation. So these are all of the fees required for the practical training of law students. I just thought I'd give everybody an overview of the different models that might exist for us. So this is for, obviously there's the need to register as a law student. This is for the practical training of law students. There's a $55 application fee. And anytime a supervisor changes, there is a $25 fee that's incurred. For the multi-jurisdictional practice, so this includes, registered military spouse attorney, registered in-house counsel, and registered legal aid attorney. There's a registration that's due for attorney applicants, because again, this is for people who are eligible for this are attorneys from other jurisdictions. That registration fee is $214. The application itself is $635. The moral character application is $551. There are no fees in the event that a supervisor changes and we are notified to make that change in our system. There are annual attorney dues, and they are the same as California licensees, which is $544 in the active rate. And for the renewal application that was referred to previously, there is no annual fee associated with that. And also, I just wanted to note other application fees. So just for the exam itself, the bar exam, just as for comparison, the general applicant fee is $677, and there's a laptop fee of $153. Halen mentioned this earlier, but there are some fees that applicants may have already paid for, and that includes a registering application. So, for students, they may have already registered, so that fee's probably already been paid. And then also, most likely the moral character application, if that is one of the conditions for eligibility in the program. Now, how these fees will be applied, these are what we know now will be program costs. So starting with the development of automation in our admissions information management system, we are going to incur a contract fee of $70,000 to implement this and automate the application portion for this program, because it does not exist in our current system. And also, we incur licensing fees each time somebody comes in. So each time an applicant comes to check the status of their application, the outcome or the status of their moral character application and so on, there are fees that we incur per login. Some of the unknown is costs that will exist, we just don't know what they are at the moment, is staff, the time and resources dedicated to processing these applications. Also, compliance and enforcement. And part of this was contingent on the discussion that we've had today of how much of that is built into this program. Now, these are various options, that exist potentially, is perhaps creating a one-time fee that's equivalent to the attorney licensing fee, which is $544. Obviously, there's also one that would reflect the MJP fee, which is $635. The thing to keep in mind is the MJP fee is applicable to people who are already attorneys, and these are students who have not practiced law. And also putting out the option of perhaps creating a payment plan, knowing that some of these students may not have the money up front, and perhaps creating a payment plan where you pay part of it, like $200 initially, and the remainder 2 months into somebody's employment, just to give them a chance to have the funds available to them. So this is kind of went quickly, and I'm not sure if anybody has any questions at this point.
So the cost is $70,000. See, I'm thinking this should be a loss leader in that we should just break even on our costs, so that the students don't get hit too hard, and the practicing lawyers don't get hit too hard, because they complain every time we get a fee raise. And it's just the cost. And that way we can justify it.
Yeah. Well, and the challenge with that is just, this is a cost that we know. We don't know is, you know, what the resources it's going to take to conduct the work. I mean, it's also contingent on how many potential applications we might get as well.
It seems to me, though, you have to know those things because you're only allowed to set the fee, I would think, at what your costs are. So how do you set a fee without knowing all of your costs? Because you can't charge more. You're going to get into the tax area at some point, which I think Neil had raised too.
Right.
Yeah, I mean, I think that's the challenge, right? Because, you know, if we get some significant number of applications, we're going to have to hire staff to process them or bring in temporary staff to process them. If we have a small number of applications, then we may be able to have existing staff prioritize their workload. And so it is a challenge. And of course, none of the costs, the known costs that Amy identified, because we are trying to be sort of sympathetic to the situation of the students. She mentioned the cost to an outside vendor to do the programming. Obviously, we have significant amount of time that our own IT staff and admission staff will be spent doing that, which if we working on the automation and making that happen, if we were costing this out in a budget change proposal that we were submitting to the legislature, we would identify all of those costs, and we're certainly trying to be cognizant of that. And I think that's what argues in favor of something less than the 544, which could be 497, but it argues in favor of something less than that, and looking at something. I think, Neil, you threw out a figure once when we were talking, I don't know if it was on this call, is there a way to do it for $250? And so I think there's some real arguments based on the sort of the conditions that we're in, that, we can do something, and sort of, right. I mean, the admissions budget is not in good shape. We have a structural deficit, so it's not like we can just absorb all of the costs, but certainly there's something that, in weighing the hardships on the applicants and versus the state bar, I think we can certainly be flexible in having a lower cost than we do for the MJP program.
And I think we have to also somewhat assume that if we do a payment plan, we might not get the payment, or it's going to come late. We just have to assume a big portion. It's interesting. I was talking to a millennial lawyer recently, and she said, Carol, people just don't pay their bills anymore. And she's an immigration. She's a poverty law lawyer. She said no one pays their bills. So I think we have to, keep that in mind too, that if we do a payment plan, people might have hardship. We might not get the second or third payment for a long time.
Well, and that could be what part of the, right? If you don't pay your fee, then that could be termination from the program.
Which is troubling too, in a way. But as we lawyers say, practicing small lawyers, if you don't get it up front, you don't get it. You just have to be happy with what you get up front. So I'm just throwing that in for consideration. And I worry about the bar not having, because they're on a shoestring anyway. So they need to get some up front to cover this.
How many people do we think are going to take on, are going to sign up for this program? I mean, I realize it's just a guess, but if you divide 70,000 by 250, that's 280. I simply offer the math without any real theory. So are we expecting 1,000 people? I guess it would even be difficult. Well, maybe we know the number of potential candidates. That would be all the 2020 classes of all the ABA and Cal law schools. What is that number?
Sorry. I can tell you what we have registered in our system, which is what I had provided earlier. It's about 6,000, let's say 450 people. But again, this is just anybody who's ever registered with us. So we could have somebody from out of state, given that this is open to other folks. It's also open, based on the fact that anybody who is eligible to sit for the bar exam under BNP code, open to law office study program folks. So there are more viable candidates. The one thing to keep in mind though is that even looking at who's, in terms of predicting who is going to sign up for this, what an intervening factor that's hard for us to gauge is how many opportunities exist out there, plus the, program requirements. Like it's a lot to buy into as an employer.
Well, and we had public testimony, remember, where the person said that not as many as you'd think are actually planning to apply. It was much lower. It was only like 40% of the people who were asked. Remember the statistics they gave in the public testimony about people who would actually do it, the program? It was lower than we thought.
Yeah, so to relate back to that study that was put forth, the study was advertised to the diploma privilege folks in a manner that clearly said, if you oppose the provisional license program, then please complete this survey. So just keep that in mind. Going back to the fee structure here, I would see a lot of the supervising attorneys being on the hook for this bill. And if a supervising attorney has the option of getting a licensed attorney and having to pay that person's fee for $544, I don't see them spending the same $544 to hire a provisional, a PLL person. So I think it has to be below $544 and definitely below $365, just on that basis alone.
You mean $635?
Yeah. Well, but below either 544 or 635.
Got it.
Yeah, I mean, below 544.
So again, as Paul Kramer asked, how many out of that? Okay, so $70,000 we think, but we don't know, it could be more.
That was just one expense though. That was the automation out of pocket.
That's the automation. Then we might need staff. So double it maybe. How many people, if you say we doubled it, I'm just throwing something out. If we doubled it, how many at $200 would we need to apply? My math is not, I'm a lawyer, not a mathematician. I mean, roughly how many?
Yeah, I'm not sure how to sort of do the precise math to figure out where the break-even point is and not beyond that. And so that's why, right, it behooves us to err on the side of a lower amount to make sure that we are not exceeding our costs.
What could, Amy, would it be possible to see that PTLS slide again?
Sure.
Do we have additional funds if this program, if we went too low, because we wanted to help people out? Are there additional funds, in other words, that we could tap to immediately if it ended up costing more than we thought while we're waiting to approve a higher cost for other people that apply? I mean, I'm not certain how it's gonna work that way, because if there is a little pot to dip into if we had to, we could err on the side of being low.
Yeah, we have a reserve in admissions. We also have a structural deficit, and so we are continuing to eat away at that reserve year after year because of that structural deficit. But is there a pot of money that could, absolutely, we could further eat into that deficit, which is going to require, ultimately, and part of this is we don't know what remote bar exams are going to look like in the future. Are we going to be able to reduce the cost, the charges for bar exams if we have remote exams? Will we need to, will we need to increase the costs in order to support the admissions budget? We'll need to do that calculation as we see what the future holds.
Did bar exam fees go down when we went from 3 days to 2 days?
No.
And that is, I'm sure, causing some people to shake or scratch their heads anyway.
Well,
Carol,
go ahead.
it's gonna be really hard to hit it on the money. It's dangerous to go too low. I'll just offer a thought. We could always, if we were willing to set a fee at what we thought was going to meet the cost, or maybe be just a hair above, we could take the unprecedented step of refunding some of the money, I guess. That would be headline making for government.
But that would be tough because then you'd have to see the total costs as they go through, I think.
And the cost of making the refund would eat up much of the surplus as well.
Right. What about the $200 and they put them on a payment plan? Now, I will say this about my clients who are, a lot of them graduating students, some of them, when they don't have money and they say, I'll pay you, Carol, in, 8 weeks or 12 weeks, a second, whatever amount it is, they pay. I mean, they want me and they know they need me, they pay. So not always. Other lawyers will tell you they get the money up front and they never see anymore. They pay. So maybe that 200 with the payment, I think the payment plan, that's what I hear a lot lately from people, is they want a payment plan. Practicing lawyers too. I like the idea of the payment plan. It gives them a little time and it's not so much up front. It'll feel better too for them to see that. And then at the same time, it covers bar. We don't, we can always reduce it later if we feel like it's going above cost.
This might be a silly question, but why is the PTL less expensive than this program would be? It's $55 for the PTL. Why does this cost more?
Amy, maybe you can talk about why the MJP costs more, because that's the sort of the comparison there.
So PTLS is obviously for students that have registered with us, and the application itself gets vetted by the supervising attorney as well as the dean of the law school. And I think the idea is also that students, we don't want to make the program too cost prohibitive. For MJP, the application has different components. There's more documents that we need to get from the attorneys, such as certificates of good standing from their home jurisdictions, if there's more than one as well. We need a positive, we need to know that they were in positive standing in each of the jurisdictions in which they practiced. So there's a lot more resources that are required for some of the documentation that's required. Same with the coordination with the moral character application. So it's got a bigger vetting process than the PTLS to start. And
but I think Tiffany's question is a good one, right? So it is the vetting process that we would need to do on this PLL closer to the vetting process that we would do on a PTLS or on an MJP. Obviously, we don't have the certificate of good standing issued from other jurisdictions. Mm-hmm. But sort of, is it closer to PTLS or is it more akin to MJP?
Well, we would need, a copy of the transcript for students that are coming in, just for confirmation for eligibility that they are a student. But yeah, and I'm trying to think of what other documents we might need. You know, obviously the moral character application. But yeah, I think it's close, more comparable to the PTLS than it is to MJP. I agree with that.
Is the fact that PTLS participants are not subject to discipline make a difference in the cost, Amy, but the MJP participants are? Meaning it's more state bar resources that are going into monitoring this program and disciplining if needed. I just don't know if the disciplinary costs are included or not.
Could be factored into that.
Yeah.
Well,
So maybe the
disciplinary
cost should
costs are
be-
in the fees lawyers pay. That's discipline, right? That's our fees. We fund discipline, right? Or is it the legislature that funds? So
No, it's because they could be subject to discipline, and because they could be subject to so for the MJP folks, because they could be subject to discipline, and because their clients could apply to the client security fund. That's a reason why we apply the same $25 discipline fee, the same $40 client security fund fee, et cetera. So it is because, so there is sort of that discipline fee would be an add that makes sense to go, to go in there.
And is that just $25 or is that more? Is that within the cost of bar dues, or is that separate? The $25 fee you just mentioned.
There's a specific $25 discipline fee. I'd have to confirm with my finance person, but there's a specific $25 discipline fee. The sort of percentage wise, the work that the bar does is spent on the discipline system by and large, and so a significant portion of the fee I think goes toward that, but certainly you could easily tie that $25 because that is specifically called out as a discipline fee.
Do we know what will happen when, I'm assuming many of these students may also take the bar while being provisionally licensed. So they're both paying for the bar exam, paying for the licensure program. And then if they pass the bar, let's say they take it in October, they apply to be licensed in November or whatever, then they'll pay another due to become a member of the bar. Does it get applied towards their bar dues if they pass, or is it prorated because they're mid-year or anything?
Yes, there's a prorate for people who pass later on in the year. So I don't have that number now, but I do know that there's a cost differential for those people that pass in July and those people that pass in February.
On their bar dues, but I think Tiffany's asking, would they get back some of their PLL fees because they didn't spend much time in the program, right?
Or have it credited towards their regular license fees.
I think I actually had that on my list, or I was wondering if there was going to be an annual fee.
Yeah, I don't think we were thinking of an annual fee, and I think part of the issue is we've got the admissions office doing the work to get the provisionally licensed lawyer licensed, right? To review the documents, ensure eligibility for the program, et cetera. And that's especially if we are talking about a low fee. If you're talking about something more akin to PTLS plus the $25 for the discipline fee, with a particularly low fee, that is really going toward the work of processing the application mostly on the front end, and then the annual fee, the licensing fee, if they then pass the bar, is really for the administration of everything that goes into them being a lawyer. So it would be hard to, other than the discipline fee potentially, it would be really hard to parse out to give them a refund for a smaller period of time, because the work has already gone into to administering their admittance into the program.
You know, I have a quick question about that discipline fee. That's to fund if they need to be disciplined by the bar's discipline system. Do I understand that correctly?
Yeah, that's part of the annual licensing fee, includes a $25 that's especially for the discipline system.
So PLLs are not subject to the discipline system, are they? They've got a moral character license pending, or they a moral character?
They're subject to discipline. That's one of the first things we decided, was that they would be subject to the rules of professional conduct and be subject to state bar discipline.
Well, I'm not sure how that works. They're not lawyers, so you can't suspend them as lawyers because they're not lawyers.
You could suspend their provisional license, right? I mean, I think it is, they are lawyers. They're provisionally licensed lawyers.
So that would be to decide whether they get to keep their PLL. I see. That was the clarification I was after, thanks.
Got it.
Well, I don't think there's any amount that people are not going to be able to tear apart. I mean, you know, because we just don't know yet enough about it to know how much to charge. So we just have to accept that. And I think we have to decide on, you know, how we see them. You know, how do we see them? More like an attorney, more like one of the students? Do we want to give them a break? How do we do it? Because there's no amount that is bulletproof.
It's not bulletproof, but the PTL program is pretty similar. I mean, it's a declaration by the supervising attorney and one by the student. There's no out-of-state analysis that needs to happen or any verification with transcripts. It's simply the supervising attorney, have them licensed more than however many years. And that, just like I do with the PTL program, it seemed like the simple paperwork. It seems, I don't see any difference except maybe the discipline.
Well, I'm not saying there's a difference, Tiffany. I'm on your bandwagon here. You don't push me off. I'm just trying to.
I've been known to do that, Carol. I've been known to push.
Don't push me off. We're riding together.
Wouldn't be the first time.
I'm just trying to figure out, you know, what we're more like, and then the fee should be more like that for now. But I think we have to make some provision for being able to change it, you know, if it's going to bankrupt the bar or dip too low into the funds, because they got to have money to operate it. So, you know, do we all agree, or do most of us agree that it's more like the, what's it called, program, the PT? There's so many acronyms. Are we more like that than a regular licensed lawyer? And if so, and I think most people see it that way. I don't think this is a temporary measure. I don't think people really see, or they will see it as much like a regular lawyer.
So we have hands up from Jennifer and from Selena. I will say that in my view, it is like PTLS plus. There is going to need to be coordination with respect to moral character, which we don't have with PTLS. There's going to need to be some coordination with the new attorney CLE, which we don't have with PTLS. So there is the plus, and then there's the automation, which I think we definitely need to have in place. So, you know, I think it's sort of PTLS plus some additional.
I go along with that.
Jennifer, Selena, and then Rob.
I was curious about how the fee waiver system works at the bar, kind of, you know, keeping in mind that we've already determined that to be eligible for this program, the provisional lawyer would have to be employed. And so, you know, for some folks, wherever they're employed, their salary would be such that maybe these fees aren't going to be such a concern, but others that are employed in public interest, you know, organizations, or even are volunteering just to get some experience in the door, it will be a much bigger hardship. So trying to reduce fees for everybody may not be necessary, but if there's a pretty robust system in place to allow us to reduce fees for those for whom it would be a financial hardship, you know, I just sort of want to know a little more about that.
And I lowered my hand because Jennifer asked my question.
So with regard to attorney licensing fees, we do have a statutory provision and a rule provision that that allows a scaling of the fee by 25%, based on, I think it's, let's see, I think it's a scaling of 25% if your income is less than, it just went up this year, it's 60,000 and change. And we also have a provision that allows a 25% waiver if a IOLTA funded legal services organization is paying for your fees. And then there are opportunities to request a fee waiver if you're a further fee waiver if your income is less than $20,000. And so we don't currently apply those same rules to the MJP program. Those are unique to the licensing fee program, but certainly there could be some consideration if some of those waivers or scaling provisions would extend to the provisionally licensed lawyer, or if you make the sort of the fee at a sort of low enough level. And I appreciate, Hylin, you mentioning the new attorney MCLE, because that is a cost that I had forgotten about, because of the way we plan to expedite automating this process. They're not going to be on what we refer to as My State Bar profile, which is where you pay your bills and where you get access to the new employee training. And we're going to have to create some bridge to give them that access, which is actually going to be at cost. But we can certainly look at extending the provisions of Rule 2.15 and 2.16 in the state bar rules related to waivers and scaling.
Selena, you have your hand raised.
Yes, I basically was going to mention the same thing that you mentioned, Hylin. I think it's sort of in the middle. PTLS has a lot more restrictions than an MJP attorney, and the same would go for the provisional licensees. They will also have a little bit more that they are able to do in comparison to the PTLS students.
But do you have more to do as far as the bar? That's the question, I think. They have more rights, I guess, or possible roles, but does that cost get incurred to the bar?
Well, as everyone has mentioned, we have the MCLE, so I guess we're trying to figure out which way is it more compared to? Is it a regular MJP attorney, or is it a PTLS student? And so I think it's right in the middle.
But I think to directly answer Tiffany's question, it seems to me that there is a direct cost to the bar in terms of needing to pay the cost to automate the system and also to build that bridge to the MCLE. So there is a cost that the bar is bearing. That is more.
Maybe I don't understand the automated piece. I know the MCLE. Does anyone first is MCLE. Does anyone know how much that costs per participant?
It's free.
No, I mean for the bar. How much does the bar pay for that? Is it just an online program that anyone can take? Is it a cost per use?
No, so we created our own e-learning portal, a learning management system where these 10 hours of new MCLE reside. And through that system, it tracks who has started the program, because you can take it over time. There are, let's see, it's 10 hours. It's, I think, 8 separate modules. You can take it over time. And so it's the tracking of it, it's the taking of it, making sure that they've done it within the year, sort of keeping all that information. And so so what we would need to do is actually build a bridge to that system in order to allow the provisionally licensed lawyers to take those e-learning courses, those free e-learning courses, because they're going to be entered into our system differently because than fully licensed lawyers or MJP lawyers. So we'd have to actually build a connection to let them take these courses, which we will do with in-house. I suspect we will do that with in-house folks, but that means other things that won't get done in the interim that we may have to cost out or contract out to have done.
So we don't have an estimate right now as to the additional cost the MCLE would cost the bar to add these students or these.
No, we're just making these decisions right now that it's going to apply, so we haven't had the ability to do that. All I know is every time I ask, how many hours does it take to automate, a change in a dollar amount from $95 to $100, I get, that's 460 hours of IT work. So I think it's always going to cost more than we would actually think that this is going to cost.
Well, and there's also just the staff time of calls. I mean, if you think about our MJP program has been around for a while, and the volume of calls that we get, just people asking questions like, hey, it could be something like, what are the eligibility requirements to, like, did you get my, such and such part of my application, or can you check the status of this? A lot of people, despite how much automation we build, want to actually talk to somebody in order to verify or override, ensure that the system has the correct information, or when it doesn't, all of these corrections or things that come up. And so, that's a kind of staff time that we really can't wrap our arms around, but I just know that it's out there. So, in terms of even resources, do we need one person for that, 3 people? That's hard to gauge, but I just do know that a dedicated staff person is going to be required just for the question answering itself. And we've already started getting these kinds of questions. We don't even have a program yet.
I think that's what makes this really difficult to try to figure this out. Is it possible, and I don't know that this is a solution, but we give the buyer the authority to set the fee at a reasonable amount to cover the cost, not to exceed a certain amount. Would that work? I mean, we still have some not to exceed amount, but if we set you at $400, maybe that's way too much. I don't know. It's so unknown at this point.
Yeah, I mean, I certainly think, Diane, that that's an option. I think it might not go over very well with the public who would be looking at the rule, and I think they would want to have a specific dollar amount set forth so they understand what the obligation is. Yeah, and it's really difficult to predict because we don't know how many people, we don't know how many staff we're going to need to hire just for this program. It makes it really difficult to make sure that we're getting that number right, because we are, to be clear, on none of our admissions process, our discipline process, or anything we do. We're not in the money making business, and so we want to make sure that we are recouping as much of our costs as we can, but we obviously don't want to recoup more than we've expended on it.
Rob, you have your hand up.
Well, I just want to echo something Donna said, and also Carol, the public perception issue. As you read in the media, the disasters that the state bars have caused all across the United States, it's just unbelievable to me. And how, with the massive size of the bar that we have here and applicants, I haven't seen any criticism of the California Supreme Court or the way the bar has been trying to deal with the pandemic. I mean, in these other states, it's a tragic comedy. So I think I don't know how to quantify it either. The public perception that we may be taking, as Carol says, a little less rather than a little more will go a long way towards goodwill. I don't know how I'm not a marketer. I don't know how you value it, but California has a great national reputation compared to everybody else right now. And I think we ought to guard that as jealously as we can. I just don't know how. So that was pretty useless, but yeah.
I want to read the press that Rob is reading.
That's what I was going to say.
Well, I haven't seen in the media any of the criticisms and the nightmares that the state bars in other states. Didn't Florida just cancel 48 hours before their bar exam? 48 hours before it was to be administered. And they spent a fortune on a software program. When they did the update, one of the takers, potential takers, discovered that all they did was take a program that Louisiana had rejected, and then they claimed that it was Florida's update. I mean, it's hilarious what these people are doing, and I haven't seen anything negative about the California bar in the media. And you know, the media can't wait to jump
Give us time. Give us time, Rob.
Well, no,
October's coming.
Rob, there is some truth to what you're saying, and it's all about relative terms, right? I think we've had relatively less bad press than some of the other states. Some of the states that forced people into test centers in July got absolutely savage for that choice, because several states forced them in without any other option. And and certainly as other bars have canceled their exams, sometimes twice, they've gotten bad press. And New York, unfortunately, has also gotten a lot of bad press too, because they did a series of decisions that were heavily criticized. So relatively speaking, but no, we're all under scrutiny here. We're all under criticism, and rightfully so. So
what about this proposal where we charge an initial amount that's pretty close, maybe $50 more than the PTLs or whatever they're called, the students. But then we have a second payment 6 months later that if the costs exceed what we've collected, we can then enforce that second payment. And that gives you guys time to hire, gives you guys time to get your figures, and also gives you a second payment. Because there's no way we're going to come up with a number that we can absolutely defend. There's just no way. And we're worried about covering costs. Can you do that? Can we do it where we charge a fee that's not, zero, but it's not a practicing attorney and it's kind of on the lower side? And you guys can get your costs. Can you do that? And then you're seeing how many staff people it's really taking. In the beginning, it's going to take more probably. Then we'll know that when the second payment comes due for people.
Diane has.
I think that's the flip side of what I said. And I think what Donna's saying is you've got to go into this so that everybody knows up front what the payment is, and then the bar just eats the loss if that's what happens.
But we can't, because we don't even know that figure of whether it's going to, unless we charge so low that we're certain it's not going to cover costs. We charge $70,000 for an estimated number of people, but that kind of screws the bar over in a time when they're already dipping into their reserve.
I just had an idea. So I remember doing research well before this meeting that there's at least 4 states that came up with rules that are roughly similar to what we've come up with, and there was relatively few restrictions on the scope of practice. And I'm wondering whether, and they've been in place for a while, longer than, of course, we haven't had ours in place yet. I'm wondering whether it's worth contacting those 4 jurisdictions or so to see how many folks signed up for their PL programs, and then use that as an estimation factor. I know Georgia's one. I think Kentucky is another one. I have those names, and I think the bar has those names too.
Does New York? If New York, that would be a good one, because they're big like us. It has to be New York, Texas, and Florida, because those states are more comparable to the California bar than, say, South Dakota.
I think New York has got far more limitations.
Oh, okay. But I mean, comparable as far as how many attorneys are out there and the whole thing, their discipline system is more like it's more comparable than a small state with fewer lawyers.
You know what else? We're not numbers crunchers. Can't we? Is it possible to send out an RFP and get some people who do this numbers crunching for a living to give us some kind of a rational estimate? We are really a bunch of lawyers just guessing about finance. It reminds me of when the Americans with Disabilities Act first came out, and I listened to a room full of lawyers trying to decide who was going to get a disability accommodation and who wasn't. And half the lawyers walked out of the room. You need doctors to do that. I don't see how we can do this sitting here today.
Yeah, this is something that you know, setting fees is something that the bar does. It's just that this is so unknown that it's more complex. You know, if we've got more known factors, then this is something that the bar could do. I can't see that we would be successful if we hired a consultant to come on and do this work.
But could we hire someone not that expensive, just like an accountant type, to say a range? Like if this many apply.
We have those people at the state bar.
Well,
Yeah.
then let's get something from them.
I'm telling you that we don't have the information. They can crunch numbers, but we don't have the information that we can crunch, and so it makes it really difficult to do that assumption. So I guess the question that I would ask to admissions staff is the administrative difficulty that would be involved with Carol's proposal, right? So and it really, frankly, ties in, Amy, to your notion of the payment plan, right? So we set a payment plan with X amount due at the front end, and then some, under Carol's scenario, some significant number of months later is when the second installment would be due. That is a set amount, with the understanding that between the first payment and the second payment, because we have numbers, that amount for the second payment could be reduced based on a determination of actual costs. So that would require you, as would just a straight payment plan, it would require you to bill people and to ensure payment. And so what's the administrative nightmare for doing that? Or is that something that you'd anticipated with the option that you put on the table for a payment plan?
So I'm just thinking about the requirements. So, the system requirements for building in like an initial payment plan and a secondary plan is something that we could probably build in the automation. I think the challenging part will be not knowing what that second payment is, but we can work at that, because it sounds like the idea is to maybe take a pause, like maybe 3 months into this program, to get a sense of how many applications and what that second payment will be based on the information that we have at that point, right? And I don't know what factors we want to look into that, is like how much we've spent compared to how many applications we've received at that point of the program, right? Is that what we'll be evaluating, Donna?
Sorry, I lost my mouse there for a second. Yeah, I mean, this is something that we do, right, where we assess if the costs are in line with the fee. So we have the formulas, if you will, at the back end to say this is what the administrative overhead was, this is what the cost for the IT was, this is what the cost for the new employee, et cetera, right? We've got that number. And I think this is just saying, right, so I'm just going to make up a number here. Initial payment, $100. The final payment due in 6 months is not to exceed $100. So we program in that second payment at $100. When we do the math, and if we determine we only need $55 for that second payment, then that's all we charge.
And if we've lost money, we don't charge more, right? We just.
Right, we would do it not to exceed.
We do it not to exceed. I make that motion.
What if?
Go ahead.
Stay on the boat, Carol. Stay on the boat. Stay with me.
I'm on it.
What if they pass the bar in the meantime before the second payment comes due? Can they get off the boat and just pay their dues?
Can they get credit for that towards their regular fees?
They should be able to.
But they've made one payment. So like, you mean if they made the second payment and then pass the bar?
Right.
Or do they need to make the second payment if they pass the bar? Or just start from there and pay the dues that are.
Yeah, like if it came due a month after they passed, you know what I'm saying? If it was close in time.
I mean, could you make an estimate as to what I know you made up some numbers. Is there any possibility, because I'm not sure what we're going to be voting on if there's a motion, and maybe we need another meeting on the cost. I mean, we've gotten 99% of the work done, I think, on what we're doing. Is there any, because for us here in this room right now to pick numbers, we don't have any data.
Why don't we start with the PTLS numbers, right? The 119 plus the 55 seems like that we've decided this is sort of PTLS plus, and the PTLS number can be the starting point, and then the additional amount 6 months later not to exceed some other amount.
Yeah, it's the not to exceed. I was hoping for some input from the bar on. I mean, it's not really fair, but
we're not going to be able to provide that input, Rob, until after the program really kicks off and we see what the numbers are.
And you're going to get the information, Rob. I think that's great what Halen said. They make it that fee. They, in the meantime, do their research. It's not to exceed, and it may not even be collected if for some reason we end up getting more than we thought. And that works.
What I want to
Because
know
then
is,
we can have another meeting to look over the finances.
what is the not to exceed number going to be? And are we going to decide that today based on nothing?
I don't think we have to. I mean, I don't think we even have to say not to exceed. We'll think of language, an amount that's appropriate. I don't know. We'll figure it out. But that buys us some time to figure out what it's going to cost. That's all we're trying to do.
Well, but I do want to say one thing. I think, you know, as administrators, I think my concern is, you know, I feel like I'm being told like I need to go, you know, make a meal, and I'm going to the store with $55, and I don't know how many people are going to eat. I don't know how many, you know, what it's going to take to get this meal completed. What I mean by that is, you know, I've already mentioned the fact that we're getting calls even after every single one of these meetings and emails, and we need staff to be responsive and on top of these. And so I know the floodgates will open, and possibly there's a potential that these floodgates will not lead to applications, but we need to be very responsive in the event that people are interested in this program. We don't want to deter people away from this. This is, you know, a very viable program for those people that are, you know, concerned about taking this next bar exam. And so, you know, we need to have sufficient staffing. I do want to just express that concern that I think we talked about the $70,000 like, you know, contract for automation. There is also a staffing. So I kind of would like to have a better assessment than the number that we come up with right now of how much we can staff up for the flood that I anticipate that we're going to get.
How much time do we have to come up with the accounting figures? Like, can you get them to us so we can have them in a couple of weeks? I mean, we're under a mandate here. We got to get this done. So can we get them in enough time? Otherwise, we have to set a figure that we're guessing at. We have no choice because we're not going to say zero.
Yeah.
So
that is why the numbers that we come up with is based on the only experience that we have with programs that exist right now.
We know that, though. We got that. We accept that. But my only question is, how, if you're saying that, then you got to give us something. Someone's got to give us something to look at in the next couple of weeks that we can meet again, or a smaller group can meet again, whatever you want to do. so that we can at least see it. Otherwise, what are we going to do? Say $300, $200, $500. Otherwise, we all have to agree we're just going to set an arbitrary number. There's no choice because we don't know.
I think the problem that they're having is that the main cost driver here is the number of people that are going to sign up. It could be 1,000, it could be 10,000, and that really will affect their overall budget. But one thing we do know is the way we've defined the program at this point, there is a defined universe of people out there that would be eligible for this program, assuming those eligibility criteria are approved. So they're not going to be able to give you that information, that perfect information, I don't think. And Amy, you can correct me if I'm wrong, until we know how many people are signing up for this. And the one thing I would add, I think Neil alluded to this, you know, we did get some feedback from people at the beginning of this process that a lot of people might not sign up for the program, but that was before this group really adopted a set of recommendations, which if approved would make it the most unrestricted PPL program in the country. And I would think if the court approves that, and they may, the justices may agree with this group, it's going to be a popular program. And so I think that it's a difficult